May I please, Your Lordship? So I beg to mention item number 2, Lordship, due to personal difficulties in Lordships. And the personal number for the Lordship.
Since it's a matter of 18, Lordship would fix it up at a very short date.
Yes, yes.
These matters are not being
Many
adjourned.
other cases have come. These are all of 2018.
Yes, Lordship, the first time listed maybe after notice was issued with,
No,
in
these
between?
are all for motion. Notice was not.
Because they were not listed earlier, Lordship. So normally what is happening in the other court, rule is being issued and fixed for hearing.
Okay, so what do we do? Issue
Yes,
rule and
Lordship.
fix for hearing.
Yes, Lordship.
Right,
But
because
no,
We are in the
without,
middle of hearing of some other matters.
the Lordship will, I understand that, but this is what was continuing. And if my friend seeks an adjournment, then it won't be listed again soon if rule is issued.
Right, so these matters you're suggesting that the court should issue.
Yes, for the ones where LCR has come and where if it's a new matter, then notice, Lordship, that's the only
You
thing.
wait,
Yes.
pass an order as it comes.
Yes.
Follow up the cases one by one.
May I please, Lordship, I beg to mention item number 14. Finally, adjourned the matter today. Because my senior's mother is illness, suddenly he
If
went
you
to
be
the
present, we'll pass an order when the matter is called up. You be present, please. Yes. The LCR has been received, we'll fix it for hearing.
Lordship.
Ms. Verma, is that okay?
Yes, Lordship.
Yes. You are appearing for?
I'm appearing for the Home Department, Lordship, and the SP, concerned SPs of the district, Lordship.
And who's for the FT, Foreigners Tribunal?
FT, we appear, Lordship. I appear for Lordship 2, 3, 2 and 3, Lordship, in this matter. Union, somebody else will appear. Deputy Commissioner Government will appear, Lordship. And for
All right, you take down, heard Mr. Asnath, Learned Counsel for the writ petitioner, also heard Ms. A. Verma, Learned Standing Counsel, Home Department, Assam, appearing for the respond numbers 2 and 3.
2 and 3, Lordship.
Mr. P. Sharma, Learned G. Assam, appears for respond numbers 4 and 6, is it? Only 4?
Only 4,
Only
Lordship.
4. The remaining respondents are not present today. Pursuant to the order dated 16/8/2018 passed by this court, LCR has been received. The same is tagged with the record of this case. After going through the LCR, we are of the opinion that are you appearing in this case?
No, he's with us, Lordship.
The matter would require deeper consideration. As such, issue rule returnable in 6 weeks. Since the respondents are already represented, no further notice is required to be called for. Let the matter be listed for hearing in 6 weeks. Interim order passed earlier to continue until further orders. Will be same order. Your name, please?
A. Rahman.
Mr. A. Rahman. Order dated 25/7/2018. Baki, Ms. Verma for respond numbers. For respond numbers 2 and 3, and Mr. P. Sharma for respond number 4. Baki hai kya hoga? Same.
Hello.
Interim order.
Item 3.
Mr. A. Mati, order on 28/2018. Okay. Ms. Verma for respond numbers. Numbers 2 and 4 are Mr. P. Sharma for respond number 2, 4 and 7. Ms. Verma for 2, 4 and 7. Mr. P. Sharma for respond number 3. Okay. Interim order to continue.
Item 4.
Please, over.
6 weeks, no, 8 weeks could do. Yes,
Lordship, the impugn order at page 32, Lordship.
it was your Mr. A. Bhattacharya.
Lordship, the operative portion, Lordship, will find at page 36.
Miss A. Varma for respond numbers 3 and 6. Mr. P. Sharma for respond numbers 5 and 7. 5, 6 and 5, 6 and 7. Order hall 13/8/2018. Baki okay.
My lord, I have a better case in a sense, my lord. My own brother has been declared an Indian. And he has adduced his evidence as DW2, my lord.
All right, we are fixing for hearing by continuing the interim order. Heard Mr. M. Mohammed, Learned Counsel, is hearing for the petitioner. Order on 7/8/2018. Ms. A. Verma for respond numbers 3, 6 and 7. Mr. P. Sharma for respond number 5. Okay, Hobo. Interim order to continue. Interim order is continued.
Item 6.
LC has been received.
SD Purcasto, order dated 7/8/2018. Miss A. Verma for respond numbers 3 and 6, and Mr. P. Sharma for respond number 5. Baki interim order to continue.
Obliged.
Item 7. Item 7.
None appears to the petitioner when the matter is called up. Matter still is adjourned for 2 weeks. Interim order passed earlier to continue.
Lordship has issued rule here also.
No, we just passed over.
Yes.
Item 8.
LCR has been received. However, none appears for the petitioner. With you.
May I please your lordship? My senior, Mr. D. Borwa, is indisposed. This
Mr. D.
matter,
Burwa, order dated 29/8/2018. Ago to rule issue for you. Achha, Ago, give the previous file. Previous file to rule issue karo. Ago to. LCR has been issued. In terms of order dated order to silo to rule. Eligible. Ms. Verma for Ms. A. Verma for home and police. Mr. P. Sharma for government deputy commissioner. It would be Mr. D. Burwa. Order dated.
He is not present. In adjournment. So, our name to know.
Learned counsel for the petitioner.
Before me.
Third learned counsel for the petitioner in terms of the order dated 29/8/2018. Passed by this court, LCR has been received. We have perused the same. After going through the LCR, we are of the view that the matter requires compact consideration, true, returnable. Ms. A. Verma, Understanding Council Home Department Assam is present on the respondent. 2 and 6, and Mr. Sharma, G. Assam, respondent number 5. Remaining respondents, although served, are not present before this court. As such, let this matter be listed for hearing. After 8 weeks, interim order passed earlier to continue.
Item 9.
Lordship, this LCR has received, like, LCR received.
Mr. J. Laskar, order on 16/8/2018. And parties are written Miss A. Verma for respondent numbers 2, 4. Are you for NRC also?
No lordship, no
2 and
one is
4.
appearing for NRC now.
Mr. P. Sharma for respondent number 3. By him, interim order, 8 weeks rule. Yes.
A2 now.
Item 10.
May I please, Your Lordship? My lord, eventually, my lord, in this case, the proceeding initiated, my lord, to the incorrect address of the petitioner. And whereas my lord, petitioner address is my lord, village Bhangra under Sanga LSC. And
will
proceeding
call for the-
initiated.
LCR may be called for lordship and
My lord, he-
interim
he
will
may
be
allow-
considered after the LCR comes. This is what is now being
No.
continued lordship.
Otherwise, original certificate copy is there.
Lordship, let the LCR come.
No,
Lordship
LCR
will
will come,
peruse
but
the
in the
LCR.
meantime, they can arrest.
No, they never get arrested, lordship.
Otherwise, my
They
lord,
are- they're still out, lordship.
If direction given to appear by fixing any date, he will appear,
No, let the
Appear where?
LCR come,
Appear where?
lordship.
my lord,
Appear where?
to the tribunal, my lord. To contest the case, my lord, because in a wrong address, the notice was served in a wrong address. And therefore, my lord, the opportunity is given to him to contest the case.
Lordship, let
But
the
for
LCR.
that, we have to set aside the order.
Because-
We can't do it after, without seeing the LCR. Or Mr.
Notice
K. Bhuyal,
LCR,
counsel
lordship.
appearing for the writ petitioner. The order dated 19/9/2020 passed by the learned member FT number 3 Borpeta in FT case number 1202 bracket capital Roman 3 bracket close oblique 2013 is put under challenge on the ground that notice was never served upon the petitioner on the correct address before rendering the ex parte opinion. Full stop. After hearing the submission of the petitioner's counsel, we are of the view that the LCR, perusal of the LCR will be necessary. As such, call for the LCR. Ms. A. Verma, learned standing counsel, Home Department,
Thank you.
Government of Assam, and Mr. P. Sharma, learned Government Advocate Assam are present. Let this matter be listed again for motion upon receipt of LCR. Right?
And item 11 is my similar situated, my lord, only case number is different.
Item 11, same order, case number to side, order, date of order and case number.
Order same date, my lord.
Order is same date.
Right.
What is the case number?
Case number, my lord, 12 bracket Roman G capital. 2023.
Order
2013.
number or case number to side.
And protection, my lord, given in the meantime.
2020, they have not arrested you for
Yes,
4
lordship.
years.
Yeah,
Then
Proceeding
because-
started in 2013, lordship is still out.
what protection you want now?
No, not necessarily.
They have given you more protection than what we can. So
But-
wait, let the LCR be called.
Obligation.
Maybe. The impugned order, case 44.
Hmm.
This was issued me lot. I appeared, I filed this claim. And my brother also deposed lot, and school headmaster also made a default. So it is held once.
This writ petition is directed against the order dated 29/1/2024 passed by the learned member, Foreigners Tribunal number 4, Goalpara, in connection with FT case number FT bracket or G-4 bracket close stroke M capital M stroke 405 stroke 2018, declaring the writ petitioner to be a foreigner of post 1971 stream. Full stop. We have perused the grounds taken in the writ petition. The matter can be considered after perusal of the LCR. As such, call for the LCR. Ms. A. Verma, learned standing counsel, Home Department, Government of Assam, and Mr. P. Sharma, learned GA Assam are present. Registered to list this case immediately on receipt of LCR. Some protection will have to be given here, huh?
It's a
In regards
recent
to the
matter,
facts
Lord.
and circumstances of the case.
Lordship, respondent 7 may be striked off because foreigners tribunal cannot be a party to the proceedings, Lordship.
We hereby direct that until further orders, the petitioner shall neither be arrested nor deported pursuant to the impugned order dated 29/1/2024 passed by the Foreigners Tribunal. Ms. Verma, those things we'll see next when the record
Lordship,
comes.
we cannot appear against ourselves. We are the respondents here. Foreigners tribunal represented by the standing council. It has to be striked off, Lordship.
No, we'll do it.
Yes.
Let the matter come up later. Now we are not even issuing notice. So it's just for motion.
So Lordship has called for the LCR
Only LCR. That's all.
and interim protection is
And
there.
interim protection.
Lordship, Lordship has passed the order. She'll appear before the SP, Lordship, SP Gwalpara.
Sorry?
Petitioner has to appear before the SP Gwalpara to take the bail, Lordship.
We are just saying that till the records are received, don't
But Lordship
arrest.
has passed it until further orders.
That's right.
That means, or till the next date.
No, the records, the matter is in motion stage.
Yes,
Notice
Lordship.
has not been issued. After perusal of the record LCR, if we find that there is nothing in this case, we'll dismiss it. If we find that the matter calls for examination, then we'll ask her to surrender. And these matters,
They're
nothing much is
already there.
happening in other ways.
Yes, Lord.
4 years back, orders passed, no arrest made.
Nothing,
The
Lord.
state police has other important things to do. This is also important,
Yes, Lord.
but wait for 2, 3, 4 weeks, then we can see. Is the Matia detention center full or there are
It's all
space?
empty, Lordship. Nobody is there now.
It's empty.
It's empty. During COVID, Lordship, everybody had to be released on. So
Mr.
Supreme Court
They have made
orders.
huge investment and the detention center is empty.
That COVID center is near my house, you know,
Huh?
about 10-12 kilometer distance.
Hmm.
Foundation school, the opposite side. There I am told me that is full Miller now. There are many detained there.
What is happening in these matters on a larger context? What is happening?
there
Hundreds
does
of
not seem to be a
cases.
proper roadmap, Lordship.
Huh?
There does not seem to be a proper roadmap happening, Lordship.
You know, who is supposed to give the roadmap? Not the
Government, Lordship.
Where is what is really happening?
Lordship.
Hundreds
Yes.
of cases are coming, is being piled up here.
Yes, Lordship.
People are neither. It's total lack of clarity on what is happening.
Yes.
This
I
is the
agree
job
with
of the
Lordship on
state. The state has to say what they want. The matters are not being pursued vigorously. Neither it has been dropped. You are just
It is
dumping the
between,
courts
it
with
is between the
thousands of
union and
cases.
the state, Lordship. The central government and the state has to take some decision on it, which
That's
is
right.
not
So we
forthcoming.
also want to know. We are just examining these opinions on a very limited parameter.
Yes,
But
Lord.
these are practically becoming first appeals. Or the net outcome is that there's a docket explosion in this court. Suddenly we have 75,000 cases. Almost half of it is FT matters. When
we
is
have-
this court going to hear these cases? When are these matters going to be decided?
Some matters have come before this court thrice. The same person has come before this court twice. First time, second time, and then a review. But all the times it had been
Correct. So
dismissed, but not.
therefore, within the parameters, 4 corners of these statutory provisions and law, there has to be clarity on what is being sought. If it is just a
Time consuming, it's a very time consuming process, Lordship, even for the courts. Even for the tribunals, even for the High Court, Lordship. At the end of the day, there's no logical conclusion to it. We are not reaching anywhere.
that is what we are asking you as the
Lordship, I've
Home Court
tried to take
counsel.
up this matter many times, but it is always deferred.
There should be clarity on these things. We would like to know as judges.
Lordship has the power to
The power, what power is not the issue here.
pass
Issue is
orders and
what is
get
the
instructions.
intention of the state? There appears to be no clarity.
Lordship, some high officer can come and address this court, Lordship. The AG, maybe the AG can come and address the court on this matter, on this issue, Lordship.
No, we are finding this exercise is becoming totally completely a superfluous exercise, except that it is keeping
I
our
completely
judging
agree with Lordship on this. In fact, most of the times I feel there's
lakhs and
lot of
lakhs of
waste of
reference cases.
judicial time also.
1,000 people deported in last so many years. What is the purpose of this exercise then? Where are you going to deport people? What is the point in putting them in detention center at state expense? There is expenditure involved in these things.
Lot of expenditure.
So there has to be an end-to-end solution to what is being sought.
Lordship, that solution has to come from the government. Government has to give us some handle to tell.
You are the
Before
government
this
right
book-
now for
Right
us.
now, but whenever this matter is taken up, it is said that nothing is forthcoming. Matter is pending before the
No, but
Supreme
you
Court.
must communicate to your officials back that the court has asked these questions.
We try to, but
What
if-
is there in it beyond just making references?
or
tribunal
maybe even
decide-
after dismissal, nothing is happening, Lordship.
Then
And
orders are passed, nobody is arrested.
nobody is there.
Then when the court is granting protection, you are opposing.
We
Opposing
are
you have
doing,
to.
we are
You have
doing
to.
our duty,
You are doing your
Lordship. At
duty.
the best, what we can do before this court, we are doing that.
Correct.
Rest is not in
You
our
means not
hands.
you individually, I am saying state.
No, I understand that.
You have to do
Lordship.
it. If you are not arresting when there is no protection, then why are you opposing protection? And then is protection and piling up matters. The High Court it will take years to decide. You don't even have an appellate tribunal. These are first
Yes.
appeals.
First, it
There
is.
should have been an appellate tribunal. And these matters, certainly, there could be many cases which are actually, which deserves an order, adverse order, but there could be genuine cases also where. So where does the citizen go? They are coming to the writ court.
It is a very unfortunate state of affairs, Lordship. That's all I can say. Very, very unfortunate state of affairs, which is not moving in
who-
any direction,
Who is
Lordship.
responsible for this?
We are responsible. The state is responsible again.
We don't want to comment on that, but all we'll advise you today is that please take up this matter with your officials and say that the court has asked for what is the.
Lordship, I would request Lordship to ask the AG to come and address this court.
Or I
Lordship
will
can
do it,
always
not
do that.
today, some other day.
Some other day, Lordship.
Yes,
Lordship can take it up with him personally also.
nothing, no personal involvement,
I mean, whenever Lordship has the time.
nothing personal about these things. Everybody is doing their duties. You are doing your duties.
Yes, Lordship.
But yes,
He can address the court and he can take up the matter in a better way with the government.
there are a large number of cases which have now become pending in the High Court, all these matters.
I
And these
understand,
are
Lordship.
practically first appeals. One has to go through the record. So it is like you have 20,000 first appeals now pending all of
More
a
than
sudden.
that, Lordship.
More than that.
More than that.
I am leaving out the expertise.
Hmm.
When is the High Court going to decide? And it's a two judges bench. So even if 20 cases are decided in a day, which is
Which
next
is
to
impossible,
impossible,
Lordship.
how
Hardly,
many years will it take?
hardly three, if there is a hearing, hardly 2 to 3 hearings are taken up. It is
And
just
these
next to
matters
impossible.
cannot be dealt with lightly. It's a question of one's
Citizenship,
citizenship.
Lordship, and then again, orders passed in 2004, 8, ex parte orders are coming up before this court now.
See the trajectory. Foreigners Tribunal is an opinion. The first shot is in the division bench of the High Court and next
Yes.
Supreme Court.
Supreme Court.
So the High Court has to be very thorough and meticulous in its findings. That is time taking. And then if the verdict goes wrong, the wrong means against the
Petitioner.
alleged
orders to
foreigners, the only option here is to go to the Supreme Court. So it's a serious business where some pondering, some application of mind at a larger canvas. You want to detect foreigners, good. Foreigners cannot stay in India. But then do it with a purpose. Do it in a manner which serves a purpose and people are not unnecessarily harassed. That's all we are saying. That's
Lordship,
all.
Justice Bujur Bora had passed an order directing the state, asking the state that declared foreigners, he had put up some conditions that And they should be given allowed work permits. If looking at the volume of cases, some conclusion the state has to come to, some decision the state. So he had set out a parameter for that. We had communicated the order, but
All right, if possible, if you can give a copy of that order to,
yes, Lord.
yes, what is the item 13?
May it please the lordships.
Yes.
Lordships is a contested matter. Order is at page 33, lordship.
Yes, page 33.
Yes, the order starts from page 33, lordship.
Contested matter, will examine it.
Examine,
Yes,
yes.
heard, miss, your name, please?
H. Betala.
H.
Betala.
Talala Council for the writ petitioner. This writ petition is directed against the order dated 18/1/2024 passed by the learned member foreigner tribunal, Kamrup Metro,
Yes, lordship.
number 1, declaring the writ petitioner as a foreigner of post 1971 stream. Ms. Betala submits that it is a contested matter and therefore the same would require deeper consideration. After going through the materials on record, we find force in the submission of the learned counsel for the petitioner. As such, issue notice returnable in 6 weeks. Since Ms. A. Verma, learned standing counsel, Home Department, Government of Assam has appeared and accepted notice on behalf of
Lordship,
Yes.
Lordship 2, 6 and 7, I would be appearing.
Lordship in 6, there is, we need to correct it because it should be DCP instead of SP border, lordship.
2, 6 and 7. And Mr. P. Sharma, learned G. Assam for respond number 5. You are appearing? Huh?
For responding number 3.
Your name, please? H. Kuli for respond number 3. Service of notice upon the aforesaid respondents are deemed to be complete. Extra copies of the writ petition be furnished to the learned standing counsel. The petitioner to also serve a copy of the writ petition upon the learned CGC on behalf of respond number 1. What about state coordinator? Is there a
Nobody
standing
is appearing. There's no standing counsel for the coordinator. also.
petitioner to also take steps for service of notice and respond number 4 by registered post with AD? On the request of Ms. Betala, the petitioner is permitted to make corrections on the designation, corrections as regards the designation of the respond number 7 and thereafter file amended cost title. The correction be carried out within 10 days from today. Call for the LCR. Register to list this case after receipt of LCR. Yes, you wanted adjournment,
Yes.
but we thought we'll allow your petition.
Nice.
Any objection?
My senior is not present. today.
Senior is not. So she has objections to allowing her petition today. What to do?
Lordship may call for the LCR. Lordship.
All right. Which is the order, page number?
And Lordship order is at, it's
44.
Lordship, it's a 2018 order, Lordship, and it is at page 44, Lordship,
So see, this is another 2018 order.
18 matter.
6 years have gone.
Lordship, the other day, we had a matter of 2004 and 2008.
So these are the problems. You see, now the court is supposed to protect the rights. We cannot ask questions why you have not arrested, why you. This is not the function of the court.
I understand, Lord.
Heard learned counsel for the petitioner. This writ petition is directed against the order dated 26/10/2018 passed by the learned member Foreigners Tribunal number 2, Nagaon, in connection with FT case number 1890/2011, whereby the writ petitioner has been declared to be a foreigner of the post 1971 stream. Stop. We have perused the grounds taken in the writ petition. Stop. Issue notice returnable in 8 weeks. Since Ms. A. Verma, Leonard SE, Home Department, Government of Assam, has appeared on behalf of the respondent numbers 2 and 4. Mr.
Lordship
P.
2 and
Sharma-
4.
P. Sharma, Leonard G. Assam for respondent number 3, and Mr. H. Kuli, Leonard Standing Council ECI for respondent number 5. Service of notice upon respondent numbers 2 to 5 is deemed to be complete in this case. Extra copies of the writ petition be furnished to the Learned Standing Council within a week from today. Petitioner to serve a copy of the writ petition upon Learned CGC on behalf of the respondent number 1. Full stop. The writ petitioner is also directed to take steps for service of notice upon respondent number 6 by registered post with AD within a week from today. Call for the LCR. Having regard to the facts and circumstances of the case in its entirety, we hereby direct that the operation of the operation remains state till the returnable date. Till the returnable date.
itu কার photo টা দিছে? না,
Yes.
Lordship, it's a contested matter and order is at page 32, Lordship.
Miss H. Betala, and then the same order like earlier. What is the date of the
Date of the order is 26/3/2024, Lordship.
26/3/2024 passed in connection with
FT case number
FT case number
1033 of
2018,
2018.
passed by the learned member FT South Salmera, Assam, in connection with so and so. Rest similar to that.
Supplementary is for motion ability.
May I please, Your Lordship? I am under protection. LCR has come, my lord, may fixed for hearing. Yes, Ms. Verma, what do you say?
This matter has come for motion. I do not have the list. It's for motion.
Orders.
So LCR has come, the order we passed in the first
Same
8, 10.
issue
I have been
rule.
given protection also.
Issue rule, Lordship.
Heard Mr. S.C. Biswal, Learned
And
Counsel appearing for the writ petitioner in terms of the order dated 3/6/2024. Records from the Foreigners Tribunal has been obtained and the same is tagged with the record of this case. We have perused the same. Stop. After perusal of the record, we are of the opinion that the matter would call for deeper consideration. Stop. As such issue rule returnable in 8 weeks since Ms. A. Verma. Mr. Pai, you are not appearing in, you are not representing FT anymore.
No, he went to one, Lordship. Court 1 also we had matters.
Oh, somebody, we marked you absent in all these cases.
I'll be there,
Yeah, you will be there.
Yes, ma'am.
Acha, the records have come, we have just fixed the matters
Yes, yes, yes.
for hearing.
That is better.
Because we have to deal with the other. Acha, in all these cases, Mr. J. Pine, Leonard SCFT. You tell him also, huh? So also after perusing Upon perusal of the record, we are of the view that this matter would require deeper consideration. Mr. West such issue no rule returnable in 8 weeks. Since who is the CGC? Anybody? Since Mr. Ms. A. Gayan Lanet CGC has appeared and accepted notice for respond number 1. Ms. A. Verma Lanet SC Home Department Assam for respond numbers 2, 6 and 7. Mr. H. Kuli Lanet SC ECI for respond number 3. And Mr. J. Pine Lanet.
Lordship, we are on the same side.
Acha, you're the
Paying
same,
and me, we are on the same side, Lordship. Same team.
same team.
Yes, Lordship.
This is Team India,
Team FT, Lordship.
Team FT. No, then how do we record his presence as what?
He's just come.
If your lordship is recording my senior, your lordship. My name, my lord.
All right, then
Anyone's
we'll record her name. Then J. Pine is not required, Ms. A. Verma. Service of notice upon the aforesaid respondents are deemed to be complete. Extra copies of the writ petition be furnished to the Learned Standing Council. Writ petitioner takes steps for service of notice upon the respond number 4 by registered post with AD. Let this matter be listed for hearing after 8 weeks by tagging the LCR. Interim order passed from here to continue. Further orders. Yes, earlier interim order may continue. Yes, good.
Obliged, Lordship.
No, teachers matters.
Supplementary list for admission. April 19.
Is foreign.
Yes, item 19. All right. None appears for the writ petitioner. Ms. A. Verma Lanet SC Home Department Assam and Mr. P. Sharma Lanet GI Assam are present on behalf of the official respondents pursuant to the order dated 17/5/2024.
Note. Very nice.
Pursuant to the LCR has been received. However, since the petitioner's counsel is absent today, any interim orders?
Very দুখাইছে এইটো পিটিশনৰ নোটিছ আপ কৰিব দিছিলে 21/5 নোটিছ 17 পাছত নোটিছখন ইছ্যু কৰিছে হৈছে নে হোৱা নাই কোনো কৰিব পাৰি
Petitioner's counsel is absent today. It appears that the counsel engaged by the petitioner, the counsel earlier engaged by the petitioner has expired. And from the office note dated 21/5/2024, it appears that a communication was sent to the writ petitioner, but there is no indication as to whether the communication has been received by the petitioner. Full stop. In view of the above, this matter is directed to be listed again after the summer vacation upon verification as to whether any new counsel has entered appearance on behalf of the petitioner. Interim order, interim order, if any, to continue till the next listing. I need the cause list of yesterday.
Yes, the me also have kept it in the file.
Yes,
No, I didn't.
education.
30 14.
Only ফাইলটো কালি যিটো ফাইলত কেছ হেৰি কৰিছিল তাত আছে বস্তুখিনি সেইটো আছে নে খালি ফাইল
Make it
না
enough.
বোৰ্ডটো
Worship, in this case, we have challenged the item number 30, my lord.
Amended provision of section 3(1).
Roman 1 proviso.
Yes.
Well, the basic challenge you have made in this petition. First of all, my lord, this proviso is repugnancy with the definition of section 2ZA, my lord. The 2017 Act, section 2ZA.
Section 17.
Yes. Section 2ZA.
hidden argument over it.
Yes.
Well, got it. The Venture ME school, including Venture ME madrasas, means an upper primary school imparting education from class 6 up to class 8 and established by the people of the locality prior to 1/1/2006, which has received recognition from the competent authority on or before 1/1/2006 and captured in the dice code up to 2009-2010, and whereof the services of the teachers have not been provincialized under any act enacted by the state legislature so far, provided that the dice code shall have to be issued on or before 2009-2010, and dice code issued thereafter shall not be considered for the purpose of provincialization of services of any employee of the institution. But here, my lord, the regarding the issuance of the order of retrospectively has not been stated in the definition, my lord. But in the section 311 proviso, this proviso has subsequently been added. The proviso were provided further that the order for such permission, recognition and concurrence shall have to be issued on or before 1/1/2006, and any order issued thereafter with any retrospective effect shall not be considered for the purpose of provincialization of services of any teacher and tutor as the case may be for the institution. For my humble submission before your lordship, this proviso has been imposed knowing fully the fact that the orders issued by the departmental authorities after 1/1/2006 by giving the retrospective effect, only to deprive the petitioner and the similar situated persons, this proviso has been imposed.
So earlier permission deadline was 2009,
Yes.
but thereafter by amendment, the proviso has been inserted, which says that it is 1/1/2006.
No, well, earlier also 1/1/2006. Earlier also 1/1/2006, but the order issued after 1/1/2006 by giving the retrospective effect with effect from 1/1/2006 and before that.
So how you are agreed with that?
We are agreed that the most of the orders, my lord, have been issued after 1/1/2006 by giving retrospective effect with effect from 1/1/2005 or several dates before 1/1/2006, my lord.
একটু কনফার্ম করে তো দিয়ে না এসব ইস্যু করে কনফার্ম এটা আমি ভাইলে লিখে দিয়ে দেখতে পড়া দিই স্কুল বিলাও করে অনেক ধরে ডেট দিলে ইয়ার পিছর সাবসিকুয়েন্ট অর্ডার ইজ সাবসিকুয়েন্ট ডেট কিন্তু উইথ ইফেক্ট ফ্রম আর এন্ডিং ডেট হবে না whereas তাহার আর্গুমেন্ট হইছে যে বিট হই দিছে it should be established by the 1/1/2006 by the local and it should dias of rights code of term থাকবে বলে 2009 তে that will establish that crucial established beyond that are continuous dias of data of school or data to that student things and everything every year কিন্তু existence থাকবে কিন্তু পিছত 16 ডেট আমরা available whether it is school
Most of the school manner the permission granted prior to 2000 also. In 94, 95, 2000, 2001, 2004, up to 2005. But I have to place.
কিছুমান ফ্যাকচুয়াল কিছুমান কেসত হইছে সাপোজ ওয়ান স্কুল এস্টাবলিশ হইছে running your school is one of them comes up with problems here your company is design and funding one of the like this বিভিন্ন কারণে more than patient bill time out that is not fault their fault সব কিনি আছে গতিকে কনফারেন্স তো দিছে সেই ডেটা sit down apply করতে everything was available people order to issue করতে দেরি করেছে and for that they are given
Yes,
In earlier occasion in the struck down act manner, these cases of the present petitioner was processed for provincialization. The district level scrutiny committee has passed the same to the state level committee, and after the completion of the scrutiny in the state level committee manner, the same has been forwarded to the government manner. I have to place manner the page 49 of my petition manner. This is the list forwarded to the government for provincialization. But already I have stated, my lord, due to the model code of conduct, my lord, for assembly election, some person similar situated has already been provincialized, but the cases of the present petitioner could not be provincialized.
all right, page number,
Page 49, my lord. This is pertains to Gwalior districts, my lord. My lord, the page 51 is the relevant. The first one, the petition number 5 school, my lord, name. Conquer Bar Emi Madrasa. In the headline, my lord, the particulars for provincialization of non-gov institution upper primary during 2013-14 as per the Assam Venture Educational Institution Provincialization of Service Act 2011, amended 2012 and amended 2013, gov letter number so and so. And the below, my lord, the signature of the members of the state scrutiny committees, my lord.
so you are referring to page 51.
Yeah, 49 start, my lord.
headline or
Page 49 start. Page 49. All the particulars of the present petition along with other similarly situated person forwarded to the government for such provincialization. my lord. But at that point of time, my lord, due to the model code of conduct for assembly election, some cases has already been provincialized, but the cases of the present petitioner could not be provincialized at that point of time. In the meanwhile, my lord, the earlier act has struck down. And the permission recognition which has been accorded at that point of time was the same manner. By giving some, in some cases, retrospective effect. And the some person similar situated to the petitioners had already been provincialized. Now, due to the proviso, my lord, the present petitioner schools could not be provincialized. My lord. And in the definition, nothing has been stated regarding this, but in the proviso, they have imposed knowingly, my lord, the fact that due to this proviso, my lord, the petitioners as well as the similar situated person could not be claimed for provincialization. That is completely in mala fide intention.
How many schools are there here? Read petition.
Here, my lord, 43 schools.
43 schools.
Yes. In the list, so many schools there, my lord. The petitioners are 43.
Hmm. Yes, so what is your argument?
Well, my basic argument is that there is a repugnancy in between the section 2ZA and the proviso of section 31131 Roman 1. And number two, since their case has already been forwarded to the government for provincialization, and the similar situated person had already been provincialized, but due to the model code of conduct, the cases of the petitioner could not be provincialized. So, my lord, discriminating treatment has been meted by imposing the proviso in section 311 of the Act. That is my basic submission before your lordship.
What is your case number?
My lord, in item number 31, case number WPC 141/2018.
Item 31.
30.
What about the other items after
That was
60?
30. My friends was 30.
I am 30.
One minute.
My lord.
Item 31, yes. Thirty and 31 are connected matters.
Connected with our lordship, same issue. My lord, while I am adopting the submission of my friend, my lord, just I want to add something, lordship. Just 2-3 points.
Yes.
My lord, in this case, lordship, there are 19 schools, lordship.
Hmm.
19 schools in the district of Karimganj.
These are all schools or madrasas?
Schools and madrasas are there, lordship.
Yes. Emi Madrasa.
Emi Madrasa. Emi Madrasa.
There is a
Emi school and Emi Madrasa.
There is a difference between madrasas proper and Emi madrasas. Emi madrasa are those schools where they give the regular routine course of education with Arabic as one of the languages. So they are termed as Middle English madrasas. Proper madrasas are totally, my lord, they go by the theological studies, my lord. So here we are concerned.
Madrasas are not.
These are not madrasas in the proper sense. They are Emi madrasas,
Emi.
where schools where English is one of the subject and Arabic is one of the subject, along with other regular subjects. Therefore, the term madrasa.
All right. In the district of Korimbo's lordship. And that all these schools lordship were established prior to 2000 lordship. And their school lordship has got permission. All the school lordship prior to 2000. And during this period, after getting the permission lordship, prior to 2000, I have annexed all the lordship permission letters lordship, that is start from page 24 onwards. This 94, 91.
And what about your batch? Their schools got permission before 2006.
No, yes, before 2000. All the permission before 2000. Some in 1994, 93, 92, 91.
But it was communicated after 2006.
Yes,
All schools were set up before 2006.
yes.
I have annexed all the permission that is pertaining to 91, 93 and 94 and 97 as well.
Yes.
Well, after getting the permission, all the scholarship applied for recognition. And these proposals were submitted, lordship from 1997, lordship, your lordship will find page 52 onwards, the proposal submitted by the district elementary education officer in the year 1997.
So all right, on facts,
But
the same thing.
why lordship, this discrimination lordship, just I have to point out that. Well, during this period lordship, 1994 to 2000, October 2005 lordship, there was a ban imposed by the government on recognition. And for which lordship recognition could not be granted prior to lordship October 2005.
When was the ban?
Ban lordship 1994 to October 2005.
1994
to 2000, October 2005. We have specifically mentioned in paragraph 4 in our petition. My lord,
paragraph?
Paragraph 4 of the petition.
Yes.
My lord, as per data collected by petitioner lordship, altogether 3,300 applications were filed for recognition. And out of which lordship, 2,200 granted recognition prior to 1/1/2006. And remaining could not be recognition lordship due to paucity of time, and marginally beyond lordship, that is 1/1/2006, their recognitions were granted, including the present petitioner 6/1/2006, 7/1, 13/1/2006, but effect is given from 1/1/2005, including the recognition granted to those scholarships prior to 1/1/2006. Effect were given to 1/1/2005, but only lordship the date of issue of the recognition order is marginally beyond the cutoff date, that is 1/1/2006. And that was lordship that could not be lordship granted prior to 1/1/2006, that is due to paucity of time lordship. Just one recognition order lordship, that is page 65. Your lordship may. My lord, proposal for recognition, your lordship may find at page 52 onwards. This proposal was submitted before the director in the year 1997. When due to lordship ban imposed by the government, recognition granted after 1/1/2006. And one of the recognition order, that is lordship page 65 onwards, your lordship will get the recognition order. Effect is given from 1/1/2005.
So this page 65, this is dated 7th of February,
My lord,
huh?
my lord,
2006.
2006. And some of the school lordship, 4th February, page 68, 2006, but effect is given 1/1/2005.
No, the recognition is from 1/1/2005,
Yes,
not 1/1/2006.
no, 1/1/2005. My lord, all the school recognition was granted with effect from 1/1/2005, not 2006. All the school, but date of recognition is given. Order was issued lordship, that is marginally beyond the date of 1/1/2006.
Mm.
In earlier act lordship, that same day, cutoff date was there, that is 1/1/2006. But so far the if a retrospective effect of issuing the order lordship, that was not there in the earlier act. In the proviso of section 311, a lordship that has been imposed, and only because of that lordship order that ought to be issued after one or before
All right,
1/1/2006.
yes. What is the next point?
My lord, only because of this lordship, the government is very much aware that most of the scholarship that were recognitions were given after 1/1/2006, but effect is given. That's why lordship that proviso has been imposed, which is lordship very much lordship discriminatory and malafide lordship, because most of the scholarship in the same way lordship recommended by the DLC, subsequently SLC, and some of the school have already been provincial under the Act of 2011. And now this petitioner lordship has been had.
Yes.
That's lordship. Master.
Yes.
My lord, I'm appearing for the item number 33 and 37 common, my lord. So in this regards, my lord, I have prepared synopsis with the case laws I am relying, my lord. I have lordship permits me to, I like to place, my lord, my lord.
Give me the case number, item number 33 and
37, my lord. So same proviso 311 of 2017 Act, my lord. And WPC 372518, my lord, first one. And another 163 2020.
but who is appearing in 32? Hold on. 32.
Item 32.
Who is appearing for 32?
AK Sharma.
Yes. 33 and 37 together. What is the issue here? Same.
My lord, same issue here, my lord. My lord, I'll have to, therefore, my lord, the factual part, my lord, I will not take, my lord. But you only, my lord,
Challenge is proviso to
311, my lord, Roman 1. We have, my lord, petitioner in petition 3725, 110, my lord. And though my visiting my learned friends has already argued, my lord, it is true, my lord, since 1994 to 2000, October 2005, there is a ban on recognition, my lord. Only 2 months there, my lord, and for to giving the recognition order, my lord. Though some of the petitioner here, I have given a chart, my lord, that even 2005 also we got recognition order, but also recognition, my lord. But the order issued after cutoff date, that is 116. Therefore, you are aggrieved in this case. And moreover, my lord, admittedly, my lord, while my lord, that these provisos come into in the act, my lord, the opening permission provided, my lord, by the state, our name also there, my lord, in the opening permission, my lord. But subsequently, in the pick and choose manner, my lord, they have given the recognition order prior to 116. We have been given recognition order after 116, my lord. Here in this case, also, you will find in item number 30, that in item 30 to this matter, my lord, the government's commissioner secretaries file affidavit, my lord, and the commissioner secretaries file affidavit in our case, absolutely they're different, my lord, and my lord, so far as we are challenging the proviso to declare the ultra-virus in this matter, my lord. Not even single whisper, what the rational principle, whether they have any nexus, my lord, why they have distinguished two equally situated persons very differently, my lord. Nothing, my lord. Only one point in item number 30 affidavit they have said to curb the mushroom growth over non-governmental institution. That is the only purpose, my lord. My humble submission, my lord. They have in the 2017 Act of 2017. Why they have chosen only 116? Why not 2007, my lord? Why 112? Only 2 months there to give the recognition order, my lord. So therefore, whom they like, they given recognition order, and whom they don't like, then thereafter, my lord. Nothing, my lord. Absolutely, lordship, I like to draw only one attention, lordship, in my affidavit, my lord. Petition in first one, item number 33, my lord. In my affidavit in reply, page number 85, kindly have a look, my lord. What do you?
Page number?
Page 85, my lord. Affidavit in reply, my lord.
Yes.
My lord, you will find that is the Joint Secretary of State of Government has this opening permission order issued on 23rd December 2005, my lord. Lordship will,
No, 1 minute, 1 minute. Page number 85, you
yes,
said?
my lord. Offer affidavit reply in item number 33, my lord. Shora Shera, Majargo, Novazagaran Girls ME Madrasa, my lord. That it.
Page number 85 is something else. Give him the record.
Second file to solve. Affidavit reply. 33 curious or 37 দুইটাই করলাম 33
Yes.
My lord, page 85, opening permission order 23rd December 2005, issued by Joint Secretary, my lord. Here, lordship will find serial number 14, my lord, that is Phalukmari Adarsha ME School, Nogo, is one of the writ petitioner, serial number 54, my lord. Here, writ petitioner. Here, lordship will find, my lord, the serial number 4, 6, 7, 9, 18, and 29, my lord. These are the school, my lord. The same school, my lord, on same date, opening permission issued. Depriving the present petitioner, writ petitioner 54, my lord. This all the schools got recognition order prior to 1/1/2006, my lord. Within a 1 week, within the 23rd December 2005, and thereafter within 1 week, they've got recognition order, but I'm been left out, my lord. So, like to lordship to draw kind attention, my lord. The chart, this schools were given the recognition, my lord. I have given the chart, my lord. Provincialized, my lord. Provincialization order, my lord. Here, provincialized, my lord. Since recognition order issued, serial number I have given, my lord. 185, 180, this is serial number 4. That is Mukhtar Kakobari ME School, Dhemaji, my lord. Lordship has find it. And yes, and also, my lord, the very next page, my lord, 115, that is here school number 6, Nobonur ME Madrasa. And next page, serial number 7, that is Ruby Balikuri Girls MEM Borpeta, my lord, that is 335 provincialized. And serial number 9, serial number 16.
Anywhere.
Yes, then my lord, my humble submission in this case, if lordship will verify the affidavit responded by this state, my lord, in the item number 30, and in my present case, my lord, absolutely, in my case, event, my lord, that thing, my lord, why did he distinguish the two similarly situated person? Why 116 as well? Particular month?
So,
Yes,
according to you, this is discriminatory. It takes
absolutely, my lord.
That's the
My
point.
lord, two citations.
We are not going to write, otherwise then
Yes, yes, my lord.
individual judgments have to be written.
Yes, yes, my lord. My lord, lordship.
We'll complete it by
That's
2026.
two citations. I'm relying Hindi in the site with my synopsis given. Lordship may peruse, my lord. Yeah, and you know, if the state
You have
responded.
filed a synopsis.
Yes, my lord. Today I have given, my lord. With synopsis
there?
to the citations, I'm relying, my lord. With citations, my lord.
We have to make a synopsis.
And my lord, my argument also covered in item 37 also, my lord. And it is after state respond argument, my lord, if lord may permit me also to give reply, my lord. Deeply obliged.
Yes.
Thirty-four. Wait, please, your lordships.
Yes.
This matter is also basically on the same footing. Here, your lordship, all the schools were particularly given the permission and recognition prior to 1/1/2006.
So you are also agreed by proviso?
Proviso that is agreed, as well as one more thing, your lordship, in my writ petition, your lordship will find at the page 308. One more thing was added here. This is a high school, and here, your lordship, I was also agreed by one more notification that is at page 308. Penultimate page.
Page 308.
These schools are all, your lordship, permission and recognition prior to 2006. Except one which was given retrospective.
How many schools here?
Here, your lordship, 70. Just a minute. 78.
Not
78.
75.
73, sorry, 76 schools. Here, page 308, one moment. This is the notification. The 31st of December 2010, there was a notification by the introduction of class 8-year education cycle in elementary and consequently 8 in secondary stage and class 5 in upper primary shall be integrated with upper primary and lower primary stage of the elementary respectively from academic section 2011. Here, your lordship, I was not agreed. Now in the next page, 309. Here, your lordship, I'll just go into the last paragraph. The board is of the opinion that as all the school mentioned above obtained permission to the above class 8 from the government of Assam prior to 2006. So my schools are prior to 2006. Hence, the board has to accord academic permission and recognitions to those schools as those schools do not come under the purview of the acts mentioned above. So then they, your lordship, issued an amendment act. Then there was an amendment act to the 2017 act in 2018, and that took away the, your lordship, that took away from us the class 8 to the lower part, and the from class 9 it was taken up as high school. So when the permission and accord was given from 2006, that ought to be taken from 8. Now, if that is taken from 2009, then my provincialization will be handled. So that here this is the issue. Earlier it was there. In 2013, your lordship will see. It was up to class 8. So then this happened.
Acha, Mr. Manan.
Yes, I'll just read that amendment.
We'll come to your
yes
other arguments. Yes. You are challenging a particular provision of the statute.
Yes.
You want the court to strike it down.
Yes.
Right? Okay. Now, on what grounds can the writ court strike down the statutory provisions? What are the grounds available?
The provision provides provision of the act which was under challenge, your lordship, at 3.1, wherein the last, wherein 1.1, it states the Vansa educational institutions which have been established and obtain the required permission, recognition, affiliation, concurrence, as the case may be, up to the last highest class required for the concerned institution.
Mr. Manan,
yes, that is what I
understand. What are the grounds on which this court can strike down the provision of the statute? We are not asking what is there in the statute. We are asking you
if it is ultra vires. That is the only
ultra vires the
constitution. Normally that is normally if an act is against the constitution, it's ultra vires
some extent, whatever provisions I am.
So your submission is that this
My
provision is ultra vires the constitution.
I'm not specific to the act. Actually, the Amendment Act actually took away. That is why I'm trying to point out the Amendment Act.
All right, amendment is also part of the act.
The only one issue, this was subsequent to the issue. That is why I'm saying, because this has taken a
No,
retrospective.
Mr. Manami.
I'm taking retrospective.
Please understand the
Mhm.
question.
Mhm.
Amendment is also an act. So
Yes, yes.
there is no problem with that. You are saying this proviso or this amended provision, adding the proviso, is ultra vires the constitution. On that ground, you are asking the court to strike it down. Is that correct?
Yes.
We have understood you correctly.
Yes, yes.
Any other ground except for that it is ultra vires the constitution?
No, I'm not taking any other.
Any other ground?
No, only that part.
So we request you to address the court how this is ultra vires the constitution.
What has happened?
We'll come to the facts and figures
Yeah,
later.
facts and figures also, I'm not going into that. Already permissions have been granted. The only thing that line and this line, that is what I'm trying to point out. This was issued in 2017, Your Lordship. In the meanwhile, Your Lordship, we have come before this honorable court. The Amendment Act comes and it takes the retrospective effect to that effect. It takes a retrospective effect, which again, Your Lordship, changes the originality of the earlier act. To that extent. That is where I'm saying, Your Lordship.
So that is ultra vires the constitution.
That is where I'm saying, Your Lordship. Just a moment, Your Lordship, I'll show.
We are trying to understand
Yes,
what is your position.
exactly. What I'm trying to point out was 311. I'll just read for a moment. The Vansa education which have been established and has obtained the required permission, recognition, concurrence as the case may be up to the last, this point, up to the last and the highest class required for the concerned institution from the respective competent authority or honor before 1/1/2006. We did not challenge 1/1/2006 as such because we have all got through by that period. Now, Your Lordship, the Amendment Act comes where they have given that, provided that the permission for the first year higher secondary clause in respect of higher secondary school, concurrence for the first year higher secondary classes in respect of senior secondary school, recognition from Board of Secondary Education Assam for class 9 in respect of high school, concurrence for TDC Part 1 in respect of degree college received from the government on or before 2006 shall be treated as permission, concurrence or recognition as case may be for the purpose of provincialization. So the change from class 8 to class 9 has affected us here. This effect, Your Lordship, is absolutely discriminatory because this was not there prior to that. At 2011 or up to this 2018, that was whichever school has been provincialized, this was not there. If it would have been 2006, class 8, nothing, Your Lordship, even if this act comes into force, I have no issues at all. But the Amendment Act, just at the moment, suddenly taking away the part where I am otherwise eligible, that is why that discrimination is there. So that discrimination is with regard to all these schools which are there affected by this recognition part of class 9. So, Your Lordship, this what I am trying to point out, the ultra vires part I'm saying is that you have taken away something after you have already made the act wherein all these schools were otherwise eligible, just to make them ineligible, you bring in this part. And this is because other schools have already been granted.
Saying by the amended provision, accrued right has been taken away.
Taken away not only from us, other schools also. And those schools were already given, Your Lordship, they have been given on class 8. Why this discrimination? This is my only point, basically. I'm not challenging the whole act, but I am only pointing out that this should be on the ground that it should be class 8 rather than class 9. The recognition should be from class 8, not class 9. But the whole, I'm not against the actually, this matter was placed saying that I'm against the 3-1 to go. I'm not against that part. The 3-1 should go or not. But the point is that these should be from class 8, should be taken as per the earlier act, not as per the amendment. That is only
from class 8 and not from class 10.
9.
Class 9. What does it mean actually?
That means the recognition and permission were taken from from the authorities when in 1/1/2006, a school will have to be having the recognition and permission with respect from class 8 to get provincialization from the authorities concerned. All these schools have got that. And they are otherwise entitled to during even in 11 and 17. Now suddenly the Amendment Act comes in 2018, most probably during or just prior to the filing of this report. Then they say, no, you have to get the permission and recognition of class 9 because class 8 has been taken away from high school. That is why I was trying to read this provision, read the Amendment Act, which says that 1/1/2006 in respect of high school concurrence Board of Secondary Education for class 9 in respect of high school.
All right, you want to read the proviso? You want to read it? You want to read it?
Which one?
The amended provision?
Yes, amended provision. I'm reading your
Please
lordship.
read it.
That your lordship 3 provided. Provided part, your lord. Provided that lordship has got that.
Yes.
Provided permission for first year first year HS laws in respect of higher secondary school concurrence for first year HSS class in respect of senior secondary school erstwhile junior college, recognition from the Board of Secondary Education Assam for class 9 in respect of high school, and the concurrence for TDC part 1 in respect of degree college received from the government on or before 1/1/2006. Now this shall be treated as permission and concurrence or recognition as the case may be for the purpose of provincialization. So if your lordship read this in consonance with the earlier act, here it does not say that. So that additional part, your lordship, is where we are stuck. Or in fact, these schools or other schools are stuck. Class 8 is okay, your lordship. 9, obviously, if we have taken the permission recognition for class 8 in 2000, let us assume 2006. Obviously, it will be taken in 2007 or 8. Even after the amendment of the act in 2011, your lordship, that notification by the government, which I have initially shown in page 309, that was in 2013, your lordship. That also given us the issue of
please come to the unamended rule 3.
Yes.
Sub rule 1, Roman 1. Proviso to Roman 1.
Yes. Provided that the order for such permission, recognition, affiliation, concurrence shall have to be issued on or before 1/1/2006. And any order issued thereafter with retrospective effect shall not be considered for the purpose of provincialization of services of any teacher, tutor, as the case may be of the institution.
So you are not agreed with this?
No, because all these schools have got it prior to 2006. I have annexed.
So the permission was communicated before 2000?
Yes, I have annexed all those. Lordship will find it is from some schools from 1995 also. And in most of the schools, all the schools except one school, your lordship, that school is at page 61. Page 61 is the only school where it has been issued in 2006.
We can provide you. How do you find it? Yes. That's
So that is the only point, Your Lordship, where I'm seeing. I'm not otherwise affected. All the, Your Lordship, from page 34, 5 onwards, all these schools I have given, they're all recorded their class 8 from 1-1, some 1-1, from 1997 till 2006, basically. All these schools, except one, which is in February 2006. That's school is Agnigar Vidyapit High School. Except this school, the others have already been granted permission prior to 2006, 1-1-2006. The issue that was with regard to recognition from the Board of Secondary Education Assam for class 9. Most of the school have got it after 2006.
earlier, as per the SEBA guidelines, these ME schools were up to class 8.
Yeah.
No, elementary,
six,
elementary
seven.
schools, elementary schools were till 7
7.
and 8, 9, 10 were high school. Then later on, it became up elementary education up to class 8.
This is the high school. These are high schools.
Just on facts, my lord, I'll just point out one thing on
One
this
second.
petition. LP, NE and high school.
Yes, no. LP school.
19, 8, 8, 9, 10.
LP school आहे.
LP 5 all okay.
That's 5 to 8. 5 to 8.
8 খন ঘুৰাই আনিছে elementary লৈ। এখানে আপোনালোকে elementary সেবাই আপোনালোকক recognition দিছিলে because
সেবাই দিছে।
SEBA was in the because 8 was in high school.
No, SEBA recognition is accepted. They have second Board of Secondary Education.
SEBA too.
But they said 9.
So when was this changed from class 8 to class 9 by this proviso?
No, it was done 2009 after the RT Act. RT Act, when RT said that elementary education would be till class 8, then from high school 8 was cut off and brought to elementary education.
With effect from?
I think this is the notification page 308.
308 is the first notification. The governor was pleased to notify the introduction of 8-year
Yes,
education
308.
cycle in elementary.
Yes, yes.
Yes. And then in the
8
page
was in-
309, this comes in.
And the recognition of these 76 schools
Mhm.
are prior to 2009.
Yes,
Is
they-
obviously prior to
Prior to
2006.
All
And
SEBA.
at that stage, class 8 was included in the high school.
Yes. That is the only case. Nothing much. Because that discriminates from the earlier ones and now. And we got stuck up with it. We can't- 2000 के last clarification. In fact, 309, that clarification has been given, page 309. Yes. That was in 2013. Even, I think, even after 2009, 2010 also they have given, Your Lordship, by SEBA.
All right.
One factual thing, he may read on facts. Per the read petition, SEBA granted them the recognition in 2013. What was given in 2005, 6, etc. was departmental recognition or permission. Act speaks of the recognition by the SEBA now. So the statement that SEBA had given a recognition prior to 2005 is not factually correct. Page 24 there.
No, Seba, that's not the case. What he's saying is, prior to 2009, whichever way you look at it, class 8 was the stepping stone for the high schools.
Yes.
All these schools had applied for permission to set up high schools with class 8 as the stepping stone.
Yes. Yes.
And the permissions were granted. Correct.
Yes.
Now they were in the process of being provincialized. So in the meantime, the act got struck down. There was a ban for some time. These are all fortuitous circumstances. After the new act came, then also their right to be considered for provincialization was recognized under the act. But by amending 311, the proviso, you have excluded these schools by inserting class 9 as the stepping stone. But that change came in the state only in the year 2009 or
But
2010.
When he speaks of a permission or a recognition being granted to them, that was a departmental permission or a departmental recognition. By law, he would require a recognition from the SEBA for class 8 or 9, whatever. That recognition which we take into account is the recognition given by SEBA,
No,
which
Mr.
admittedly
Mohta,
was given in 13.
that we are not interested. We are not going to go into whether X school out of 76,
No, all the
who
schools.
is entitled to,
All the
who is not
schools.
entitled. We are not going into that.
True.
We are not. These facts are only essential for assessing the argument that the amendments are unconstitutional. That's all.
Yes.
Even if we hold that it is unconstitutional, even then, how many of these petitioners will actually get relief or not? That's a matter of inquiry by the department and fulfillment of condition. We are not going to either ways, whether we accept their arguments or accept your argument, we are not going to issue a mandamus that give him this recognition, give him that recognition. We are only going to clarify what is the legal situation.
What I was trying to submit is if he does not, if the petitioners cannot show that they had any inkling of a
We
recognition
are
from
not
the SEBA.
going to go into that. So why are you arguing that? We are not saying whether the petitioners are entitled or not. We'll only say whether this amounts to
A
taking away
discrimination.
rights and is discriminatory. That's the only thing we are going to argue. If we hold that it is discriminatory, they will have their remedy under the law. Whoever succeeds, succeeds. Whoever doesn't. They have all approached this court complaining about these provisions.
Yes.
And for embellishing their claims, the facts are necessary. But in a 30 through 82 petitions, we are not going to grant individual reliefs to any of the petitioners. That the petitioner should be very clear. Then we'll have to hear each case separately. First, let us decide one case each on the question of law, and then accordingly we will consider. Because in 82 petitions, we can't get into individual facts and grant relief. That's not happening in this batch. We are making it very clear. We'll only examine the challenge to the statute. That's all.
So that is only my point then, Your Lordship. No further factual part.
That's it. Otherwise, it will be an unmanageable task if we have to discuss all these things and go into individual facts. These 76 petitioners, so and so applied on such and such date, so and so applied. We can't go into there. We will not. We will not. We're making it very clear.
Maksud.
May I please, your lordships?
Yes.
These are high school lordships. Those schools are established in between 1989, 1995, and accordingly got prior permission from the departmental authority, and class 8 was also recognized. Initially, it was established from class 8 to 10. Subsequently, it was shifted by learning already submitted in this regard, lordship, shifted class 8 to the elementary. If it was a part of the elementary, secondary education, lordships, that petition will have no problem. Here is the case, lordships, all the petitions are eligible because only sex proviso of section 3(1) lordships.
All right, don't repeat. It's
Lordships,
all
but
about.
I am not repeating lordship because the
what-
fault, yes, lordships. I have, my submission is that they have made classification in the same set of employees. Very object of the act, lordships, to provincialize the services of the employees, the benchmark institution. But at the same time, they have made classification that is not permissible. So that forbids Article 14.
What
lordship.
is the classification?
Classification, lordship. At the same time, other institutions, lordships, established, authority gave permission, class 9 opening permission prior to 2006. My institution established at the same time, they have took more than 10 years delay in getting the permission to obtain class 9. But class 8 got prior to 2005.
So argument is discriminatory.
Lordship,
Yes, anything
discriminatory.
else?
Only on that point, lordship, my lord, I will submit to judgment, lordship, but unfortunately, I lost 2 sets. May I, after lordship, half an hour, I place the judgment. If your lordship permit me, may I read this relevant paragraph, lordships? That is AIN 1983. So SC
What is
130.
the point?
The point is that, lordship, DS Nakara versus Petition Union of India.
DS
I-
Nakara pension matter.
A pension matter, lordship,
What is
paragraph
the
9.
point you want to argue?
Point argue, lordship.
Right
take-
once accrued cannot be taken away.
Lordship,
You give
take-
it to her. Anything else?
Lordship. Another is, lordships, Union of India versus NS Ratnam.
Rangadhamaya.
Ratnam.
Same
lordship.
point.
Same point.
Give it to her.
I'll place.
All right.
I have also taken written argument, lordships. I will place her. This is my submission, lordship. Oblige.
Take them and name, write the name of the council and case number. Yes, next matter. Same.
May I please, your lordship?
Yes,
I have also
yes, please.
written argument, lordship.
All right. Yes. This is also proviso to 311.
Yes, lordship. First, I read the written argument, lordship. The petitioner at the secondary high
No, no,
school.
that's not working out. Give us the point. You can't read this whole thing now. Because we have already heard, don't repeat. What is the, you have heard the submission of others.
Lordship,
What
question
is the
that,
extra thing, new point you want to argue?
just extra, lordship, there is a, I filed affidavit, lordship. And the government and our association, the high school association has agreed in one point, lordship. Those schools whose students are appear in before 1/1/2006, they may be considered in provincial election.
Students has appeared means?
Before in higher secondary, high school living certificate, HSLC exam, they may be considered provincial election. Those agree, lordship.
In this affidavit, I also
Where is that? Where is that? Where is the agreement?
affidavit, Lordship.
Affidavit, there is an extra file. No, it is here. Which para of the affidavit?
I just annexed the minors, Lordship. Annexer 1, page 6.
There any affidavit filed here?
Meeting was 5/11/2020, Lordship. And provincialized of Venture High School, point 1, Lordship. Second para, during the course of discussion, the Assam High School Teachers Association pointed out about the matter consideration of school for provincialization from which students appear in HSLC examination prior to 2006 onwards. The matter will be placed before RC Joint Commission by the Director of Secondary Education as well as Assam High School Teacher Association. Lordship, it is also signatured by the Commissioner Secretary, Government of Assam, Education Department, Dispose 6, Lordship. And second,
Have
my
you received the copy of the affidavit? Is it there with you?
Office might have, my lord. I do not have a copy as of me handy now. But that is only what the association would have agreed to is what perhaps is reflected, yet to be placed before any committee.
So
Second
let us
point
see-
is, Lordship,
one
I-
minute, 1 minute. Let us see what is the first point. What has been agreed? Let us please see. Please read.
Lordship, page 6.
Hmm.
First point, provincialization of Venture High School.
Hmm.
Second paragraph, Lordship. During the course of discussion, the Assam High School Teacher Association pointed out about the matter consideration of school for provincialization for which students appear in the HSLC examination prior to 2006 onwards. The matter will be placed before RC Joint Commission by the Director of Secondary Education as well as the Assam High School Teacher Association.
So
it is government minors, Lordship. It is signatured by Commissioner Secretary, Government of Assam, Education Department, Dispute. Next page, Lordship.
So what is the decision?
Decision is that already we submit all documents pending, Lordship. Next question is, Lordship. Another point we also include, Lordship. Those who have school who has get the SEPA code. One is DICE code, another is SEPA code. Those who get SEPA code, they are eligible to sit the HSLC examination. That is school. They may be considered on that way, Lordship. We have no objection. And third, Lordship, one thing, most of the schools are already closed. So in a recent, Lordship, 30% of HSLC examination last conjugal 3 years may be considered. So it may be minimized, Lordship. In I written argument, I clearly written, Lordship. 3 point, Lordship.
Yes.
Obliged.
Written argument.
May it be to your Lord.
Yes.
Here also the petitioners are belong to Venture High Schools, Lordship. There are 4 schools of Venture High Schools. And we are also aggrieved by the same proviso of the amendment of the 2018. Although we have been given permission with effect from 1/1/2006, but order of permission is issued after 1/1/2006. So by invoking the proviso of this section 3(1), the state respondents say that that the retrospective operation of the order is not permissible. So consequently, the petitioners are deprived from getting the benefit of provincialization. Now also I like that the permission and recognition. So far, in respect of the
That's
high
the
school.
point. Your school got recognition prior to 1/1/2006,
Yes.
but the permission was granted, communicated after 1/1/2006.
Order issued after 1/1/2006. I have enclosed those
What is the
permission.
date of the order? How many schools are there?
There are 4 schools, Lordship. Lordship, I have enclosed my permission order. Lordship, I like to draw your Lordship attention to there's such order at page 42. Not only 42.
Yes.
This is the initial departmental recognition order issued in 2004. Then page 42, this is the order for permission for class 9. Actually, although it is reflected the recognition, but what for class 9, it is only the permission. What the regulation stated 1988. That is why I will come to that 1988 regulation. So permission in respect of class 9 was given with effect from 1/1/2004. Order issued 17/8/2006. Now, because of the section 311 proviso, we are not eligible since this order is issued after 1/1/2006. Now, this permission and recognition is given under this by the SEBA rules, Lordship. Now, Lordship, kindly come to the regulation 1988. How the permission.
That's the point.
No,
The question is not whether the permission is granted properly or not. Question is whether the
discrimination.
proviso infringes upon the rights of the
Yes.
educated. That's the point.
Yes.
What else is to be
They
argued?
are trying to differentiate classes separately, so far the petitioner is concerned, and for those schools which have already been
It is
provincialized.
discriminatory.
Yes, Lord.
Nothing more is there to be argued here.
And one point is also that the
We are
government.
not going into how you got the permission,
Yes.
whether SEBA should have given. These are all things that will be looked into if you succeed.
Lordship.
That is a matter of whether permission is valid or
Although,
not.
yes, Lordship, although they have
These are
said
not
that
things we are going to go into these.
cutoff date is 1/1/2006, but there is a
There will be no relief on individual basis in any of these batch of writ petitions.
Lord.
It is only the declaration on the validity of the law,
That
whether
clause.
this provision is statutory provision is
Clause.
valid. If so, if not, it is to be struck down or whether it should be read down.
Lordship.
That's the only thing we'll answer in this batch.
Lordship.
And in the light of the decision, individual cases will be dealt with by the authorities.
Separately.
So
That's
why
just
are
so-
we going into individual?
Yes,
facts?
Lord, there is also notification issued from the department itself. By this notification issued in the year 2013, where the government took for the first time a decision not to grant further permission and recognition. So my submission is that although they have took a cutoff date of 1/1/2006, they have chosen that particular without any reason.
Where is that notification?
That I was it is a copy.
Give a copy to Mr. Majumdar. or-
Yes. 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 So this was issued under the Governor of Assam Lordship on 26th of December 2013. The last paragraph, Lordship, as per section so and so Assam Bhensa Education and so, there is no permission or recognition or concurrence or affiliation to be issued for the Bhensa educational institutions henceforth, Lordship. So the decision there, the cut off the 1/1/2006, there is no basis, Lordship. Whereby we are deprived, Lordship. At least, Lordship, the authority came up with a decision only in 2013. The 26th December 2013.
Mr. Majumdar, please tell us what is the meaning of this notification? Your act says 2006. Governor's notification says
It is told
That
it's in
no
all
institution
documents.
established after 1st of January 2006 will be considered for provincialization. Therefore, no permission or recognition of concurrence be issued to any educational institution henceforth.
so established after 1/1/2006. That's understandable.
It is.
But then if there is delay on your part to record permission,
Issue the orders.
then-
And for high schools, the recognition comes from the SEBA. The delay, if any, had to be on the part of SEBA. SEBA can clarify whether those schools existed prior to
that is
116 or
another
not.
matter. We are asking you that this makes it clear that institutions established up to or prior to 1/1/2006 will be entitled to permission. Correct. Now, these are the petitioners who are claiming that they had all established their schools and got recognition
Prior to 1106.
Delay, if any, was only with regard to formal communication of the permission. Because there was a ban, government imposed ban. And once the ban was lifted, and there were other reasons, MCC, etc., the permission was communicated. The date of communication was after 1/1/2006. But that itself has become a stumbling block because of the proviso inserted by the amendment of 2018, which is the ground on which they are assailing it. But these notifications appear to be tilted towards the arguments of this does not say that not only established but permission received. Formal permission received. That's not there.
The law, my lord, did not permit establishment of schools. Permission is for establishment of a school. Their permission is after 1106 or 110.
So far, we have
How
only
they-
heard cases where all schools were established prior to 1/1/2006.
That establishment had to be preceded per law by a permission. They say we have established and then we came up for a permit, then we sought the permission. The permission to establishment has to come. Then they could have been established. That is
a matter to be discussed and decided on individual cases. You can't.
when they
as a
say
law-
we had an established school and we were seeking permission and that was delayed. That cannot be the case unless a permission is there.
No,
how could
they are
the school be
saying
established.
Any school which is established prior to 1/1/2006 cannot be denied benefit of provincialization by.
What exactly page
That
35?
establishment has to be preceded by a permission.
That is a matter to be decided on individual cases.
As a whole, my lord,
Achha,
a school
alright,
cannot
then-
be established without a permission.
All right. You have either understood and you are avoiding it, or you have totally not understood. Whether an individual school has been properly established or not, we are not going into that. Because some schools have not been established properly, so you pass a law to say that nobody will be granted permission. Okay, no, do that.
No, we are saying that if the permission is after 1106, we do not consider you for.
But if this school is established prior to 1/1/2006,
It could be established after after the permission. So the prior to establishment, the permission will be there. They'll be considered for record.
but in other cases where they have first established the school and got permission.
Those schools establishment is not possible without a permission.
All right. All right.
The law says that
All right,
when
you
someone
you
wants to
argue this
establish.
point. Keep it.
So that is why the regulation says after establishment, they sought for permission and recognition from the SEBA under 1988 rules. And page 35, the departmental permission has been granted prior to 1/1/2006, 2005. And the word recognition in a clause, it is not the recognition, it should be the permission law as per the 1988 rules, regulations.
Yes. That's all.
Oblige law.
Mr. Majumdar, don't confuse the two. It is one thing to say that these schools were never established before 1/1/2006.
Yes.
Because they did not obtain the permission prior to establishing.
Yes.
That is one thing. It is another thing to say that even if you have established it before 1/1/2006, if the permission is granted later on, then we'll not give you.
I understand.
That is
I
a
understand
completely
what is.
different thing.
I understand what is falling from
It's a
lordship.
different thing, because even under the new act, you allowed it only to be taken away by a subsequent amendment by the proviso.
That proviso.
Therefore, we will look at it from that angle only.
Yes.
So we are examining the validity of a statute. We're not concerned about who gets the benefit and who doesn't get.
I understand.
These facts are necessary only to ascertain the locus that the affected persons are before the court. We'll just complete the catalog of facts on that, nothing more. But if the statute confers that right and takes it away, then certainly this will come in the purview of. And yesterday we mentioned that the clause 2H says that not only those which have been provincialized, but which are going to be provincialized.
Yes.
This is a peculiar suffix we find in this statute, because in no other statute you find something like this. What will happen in future? The statute
Is also provided for.
statute is always a concurrent document. It is going to hold the field as long as it is valid and in force. So it is talking about not only provincial under this act, but also those in future. You have to explain that. What is the meaning of that? What does it mean? If there is no other meaning, then we have to accept the argument that there was a clear recognition of right of provincialization even beyond a particular cut-off date. So that is an answer. We are mentioning this so that you can make a note and address the court. Yes, next.
Offline.
Item 14.
Lordship, it is. Same submission, Lordship. 38 and 47, Lordship. Also, I am submitting an argument in same.
How many schools?
Only 3 schools, Lordship.
Yes.
Offline.
Group C, item 41.
In this group, my lord, it may be my lord group along with 13, my lord, group number 13. I have challenged the my lord 3-1 Roman 11 of the A.
Yes.
My lord, this group, my lord, maybe take with group number 13, my lord. Because, my lord, the same, my lord, 3-1 Roman 11, my lord. And today's cause list, it comes from, my lord, item number 54 to 69.
All right. Then you call. Why don't you call item 42? 42, you're appearing 41.
My lord, 41.
You
my
say
lord.
it should be taken with group 13.
Group 13, my lord.
All right, we'll move on to the next matter,
My lord.
item 42.
My lord. Oblige.
Who is appearing in item 42?
Lordship, I have prepared a small synopsis.
Yes, please.
How many petitioners are there? Eta copy this one. Eta copy this one. Look.
Mr. Kalita, how many petitioners?
In this case, Lordship, 77 petitioners are there. So this is little bit different than other cases, Lordship. Why I'm saying so is that like we have in the petitioners list, there are other than the teachers, there are the staffs are also there. There are a couple of staffs, I mean, lab assistants and all, they are also there. We have initially also when we filed this case in 2018, then that actually for the staff, for the non-teaching staff, we were not aware that there was a different act which has already come into place. So we have challenged this because in this particular act in 2011, it was for the all staff, teaching, not teaching. But 2017, they have brought this 2017 only for the teaching staff. So they basically initially left out those non-teaching staff. So we have challenged this 2017 in the presumption that they have not got any other act to cover those people. So subsequently they have got it. So we have filed an affidavit in reply. So we have stated that that act may not be separately challenged because if 2017 goes, then automatically that will also fall in place. So we have filed an affidavit in reply to that because we got to know when they filed affidavit in opposition only. So Lordship, in this case, all the petitioners are basically they are teaching, non-teaching staffs of high schools and high school madrasas.
Yes.
So Lordship is already aware that like how these venture schools have come in, Lordship, that people from the locality because of non-availability of the schools and all, people from the same of that locality of the couple of villages, they used to donate land, they used to donate money. So infrastructure is built up and that local people only they start teaching in the schools and all. So this trend was going on because this was kind of a custom which was going on in far-flung villages and like underdeveloped areas. Now this was going on for a certain period of time. In 1977, Lordship, the government has come up with an act to provincialize those schools. So that like schools are basically running by without any proper fund. So they want to bring those schools under the government's management so that some financial aid could be given and the teachers and students can be helped out of that. 77 happened, then 88 happened. 88 Act says that how this schools should be recognized, how permission should be granted. All these aspects have been covered there. Then this provincialization was going on at a regular intervals. From 1995 to 2005, almost 2005, then somehow there was kind of a ban. It was not, this provincialization was not happening. But the schools were being set up and schools are growing all the time. So from 1995 to 2005, there are a lot of applications were filed before the government for provincialization of their schools because they fulfill the criteria, other criteria. So they need to go for provincialization. So a lot of applications have been filed. Applications got accumulated because there was some kind of a ban in provincialization of the schools. Now 2006, Lordship, the government realized that a lot of schools have happened. They're like these schools are basically imparting education, and they should be helped out, and like this should be stopped because like maybe there was a concern that like quality of the education is also going down. So it should be stopped. So the proper management should come up. So in 2006, they have started giving provincialization, recognizing these schools, and they wanted to provincialize those schools. So in my cases, Lordship, all these schools have been recognized. But like only thing is that like some schools, what the recognition has been given later on. I mean, 1/1/2006 was the date. So what they have done, I have already applied, my application was there, school was established, school was running. So what they have done, they have given that like your school is recognized from 1/5/2005, but they have given it in 2007 or 2008. So retrospective effect was given. Now, point is that, Lordship, in this case is that in the intent of the 2011 Act as well as the 2017 Act is same. So basically, they want to bring because these are all existing schools. They are not doing it for prospective schools. These are already existing schools and those who have been recognized. So our schools have been recognized, and our schools, our teachers' names, our staff's names have been published uploaded in the government portal, saying that your names have been recognized, and you are eligible for your services to be provincialized. So that promise has been made by the government by putting our names in the government web portal, saying that you are eligible to be provincialized because your school is already recognized. That has happened, Lordship. In the meantime, Lordship, what has happened is that 2011 Act was challenged. The 2011 Act was held as unconstitutional, and it was struck down. It was specifically struck down. So now they have come, government has come.
Was it struck down?
It was struck down, Lordship. It was struck down because it has been written in the judgment, Lordship. It was struck down. So now the review petition was filed. In the review petition, what has happened is that like there were around 72,000 eligible people at that point of time. Out of that, they started doing this provincialization. Out of that, 42,000 people have got provincialized. So what happened is that our petition we got stuck up because of our this act has gone. Act is already so.
Till the time when the 2011 Act was interfered with, about 42,000 something or
got provincialized.
Teachers got provincialized.
Correct, Lordship.
And another
30,000
were in the pipeline.
Correct.
They are the ones who are now
before your Lordship. So my Lordship, factually, Lordship already they have been, our Lordship is aware of this. My argument will be based on basically, Lordship, couple of legal points. That is, one is, Lordship, that legitimate expectations, since I have been working in those venture schools, and there was a customary trend that all these venture schools are in certain point of time being provincialized. Now that was a custom.
Mr. Kalita, you are not challenging the statute.
I'm challenging it.
You can't challenge statute on legitimate.
No, there are other points also. I'm just coming to because one thing is, Lordship, that while making this classification within a class, whether the principle of intelligible differential was maintained by them or not. This is because bringing in that proviso, I'm challenging 311 proviso, because 311 proviso was why this cutoff date was suddenly brought in, and whether this cutoff date.
Right, which are these provisions you are challenging?
Yes, Lordship, I will come. So I am challenging, Lordship, section 2J, 2J, 2X, 2U, proviso to section 311, section 6, section 7, and section 24.
All right. So let us then have a look at this.
Correct. I'll take your Lordship to that. Lordship will find that 2017 Act at page 84 of my petition.
Yes. You may refer to the provisions.
Yes.
We have made our own compilation, so we'll follow that.
All right.
Let us see 2J.
2J, Lordship, that employee means includes all serving teachers and tutors, as the case may be, of venture educational institutions who have been appointed and joined in the concerned venture educational institution before the 1st January 2011, and whose services are being or would be provincialized under this act. So this was done because, Lordship, that as far as non-teaching staff, that was not included at that point of time. So this employee, we have actually definition of employee leaves out that non-teaching stuff. But subsequently, they have of course brought in another act covering those people. So that's why we have challenged this. Then Lordship, two acts.
Yes.
Venture High School means high school imparting education to class 10 and established by the people of the locality prior to 1/1/2006, which has received permission from the state government and recognition from the Board of Secondary Education Assam on or before 1/1/2006, and whereof the services of the teachers have not been provincialized under the act enacted by the legislature so far. So we this is also in context of 3.1, Lordship. 3.1. This has to be read with 3.1, Lordship. Then 2U, Lordship. Tutor, Lordship.
Yes.
Tutor means and includes teachers, assistant teachers, classical teachers, and also includes lecturers, assistant professors, associate professors, professors, principal, vice principal, demonstrator, headmaster, assistant headmaster, superintendent, assistant superintendent in a provincialized educational institution under this act who are not eligible for provincialization of their services and whose services cannot be provincialized in the post of teacher under this act due to lack of his, her educational and professional qualifications required as per the right of children to free and compulsory education act 2009, National Council for Teachers Education Act 1993, University Grants Commission Act 1956, and relevant rules and regulations framed thereunder, and any other act as the case may be as applicable on the date of provincialization. However, his, her service provincialize the tutor with separate terms and conditions of service to be notified by the competent administrative department, provided that a tutor shall not be eligible to hold the post of professor, principal, vice principal, headmaster, assistant headmaster, superintendent, assistant superintendent, as the case may be in an educational institution provincialized under this act. This has to be, Lordship, read with, again, Lordship, with section 6. Wherein, Lordship, that qualifications of the tutor and the provisions of tutor has been laid down. Then Lordship 3.1.
Let us read section 6.
Section 6, Lordship. I'm sorry, Lordship, it should be section 7, Lordship. Section 6 is qualification for section 7. May I read, Lordship?
Yes.
The tutor must acquire the prescribed educational and professional qualifications within a period of 5 years from the date of publication of the order of provincialization of services of the teachers and or tutors of the concerned venture educational institutions in the official gazette, and after acquirement of required qualification, they shall be upgraded to the post of teacher in appropriate cadre. If such tutor fail to acquire any such prescribed qualifications within a period of 5 years from the date of publication of the order of provincialization in the official gazette, their cases shall not be considered for upgradation to the post of teacher after the lapse of a period of 5 years from the date of publication of provincialization order in the official gazette, and they shall continue to function as tutor as for the terms and conditions which were applicable to them before the provincialization of the concerned venture educational institution. So this provision also we are challenging. We are challenging this provision because saying with the contention is that they have given 5 years, Lordship, period for getting this degree. This is the degree is basically the additional degree they have included is basically B.Ed degree now. Now, B.Ed degree, what happens, Lordship, in our schools, we have been working in those schools from ranging from 20 years to 26 years. Let us take up the case of 26 years, somebody who is serving in the school for 26 years. Now, he has, at that point of time, at his entry, that qualification was not B.Ed, qualification was higher secondary. Now he has got into the school with the degree of higher secondary. Now he cannot get into a B.Ed college because he is only higher secondary. He doesn't have a degree. Now this bringing in this clause, basically you are curtailing those people from getting the provincialization. Their services will not never be provincialized because his entry point to his entry qualification was different. That is one aspect, Lordship. And second aspect was, Lordship, that some people are already on the verge of retirement. So 5 years time they are retiring, or a couple of my petitioners have already retired. So those people you haven't considered. So they will remain as a tutor. And Lordship, another thing is that a person before provincialization who has been imparting.
So Mr. Kalita, what is the argument then? This is the effect. What you're mentioning is the effect of the act.
So what I am saying is that, Lordship, the
Statutes can have adverse impact on some people.
correct, Lordship,
That's not a ground to strike.
No, Lordship, what I am arguing is that by doing this, basically you are classifying the same class into different classes. This tutor was also imparting education as a teacher only, and he will be teaching only. He will not do anything else. He will be teaching only there, but with a different terms and conditions. But his job is not be taken, will not be taken away. He will be a teacher only in the school. His job will be teaching only. But you are doing a separate class by bringing in this. I'll come to that, Lordship. I'll come to that because my basic argument will be, Lordship, on the basis of this proviso, 3.1 proviso. So 3.1, Lordship, I'll just take your Lordship 3.1.
Amended
Amended proviso.
Yes.
Section 3.1, subject to the provisions of Article 30 of the Constitution of India, the following categories of venture educational institutions shall be eligible for being considered for provincialization of the services of their teachers and tutors. Venture educational institutions which have been established and have obtained the required permission, recognition, affiliation, concurrence, as the case may be, up to the last and the highest class required for the concerned institution from the respective competent authority or authorities on or before 1/1/2006. Provided that the order of such permission, recognition, affiliation, or concurrence, etc., shall have to be issued on or before 1/1/2006, and any order issued thereafter with any retrospective effect shall not be considered for the purpose of provincialization of services of any teacher and tutor as the case may be of the institution. So what I am submitting, your Lordship, is that there was a homogeneous group of 72,000 people. Some people, in those 72,000 people, there's a mixed group where maybe there were some people who have the BA degree. Someone, they do not have BA degree. And some schools have been recognized prior to this, some schools may be prior to this. Now, some of the, out of that, 42 people you have provincialized. 42,000 people you have provincialized. Then you have left out 30,000 people. Now, by bringing in this act, you have stopped those 30,000 people who were equally placed. They were standing on the same floor. How can you do that? Whether you can classify, you can classify these people with some reasons, with some distinguishing factor.
That's what they're saying. These people are not graduates. They are willing to provincialize the graduates.
But in the 40,000 people, they have already provincialized. Out of those 40,000 people, they have already provincialized. There will be thousands of people who were not graduates. So one graduate that he had been provincialized only because his application was taken first. And my application somehow.
Mr. Kalita, if you have understood your argument correctly, what you are saying that when the 2011 Act was in force, number of teachers, their services were provincialized, although they were not graduates.
Correct.
Correct. The process would have gone on to cover even people who are your clients, like your client. But unfortunately, the act got struck down, and under the new act, they have come up with certain conditions. One of which is that one has to be a graduate.
That is one.
That is one, right? Now, there is also a RTE Act of 2009.
Correct.
Which requires the teachers to be graduates, right? So the act which they brought on 2017 apparently is in consonance with the requirement of the 2009 RTE Act. But leave that aside for a moment. Your argument that there is no basis, there is no intelligible differential rate, there is no reasonable classification. Here we want to ask you, are you saying that the government is not competent to bring in a legislation prescribing enhanced qualification for, say, provincialization of teachers in this case? In some other case, it could be for promotion. There are many cases where the act comes in which says that you cannot get promotion to the next post unless you are a bachelor's degree holder or a BA. Earlier, people entered as higher secondary, but now for a promotion, suddenly after 30 years, the act comes in, says that if you want to be promoted, you have to have a graduation. And these acts have been challenged, and there are decisions of the Supreme Court as well as this court, wherein it has been held that this is not discriminatory. They are entitled to, the government is entitled to bring in legislation prescribing higher qualification. At the most, in some cases, relaxation is what has been resorted to. So viewed from that angle, your argument that this is discriminatory. Maybe
That is one argument, Lord. So that is only one part of it. The second part of it is the most.
Let us go one by one.
Correct.
What we are saying is the argument that it is discriminatory may be difficult to accept on a legal touch.
No, that I am aware of the legal this thing, Lordship. But only thing is that, Lordship, in addition to this, this cutoff mark has taken away my recognition. My school was also recognized at this similarly, Lordship, giving retrospective effect, and those people, unlike that, Lordship, has to recognize one thing, that this act, the intent of the intent object of this
is to provincialize.
It's provincialized. It's for the existing schools here. It's not for the prospective.
We'll continue. Mr. Barbara, you are waiting since morning. Which is your item?
Actually, going by the challenges of viruses, my case actually fits in group 2, group 4, perhaps because the case was filed as a last case, my lord, that has been put in the last group. Actually,
but
yeah, I fall in group 2.
Yeah.
The way it has been grouped.
But we thought the icing in the cake will be done by you. Therefore, we are also waiting.
No, my lord.
Let the preliminary arguments be over. After that, Mr. Das is there, you are there.
I am in group 13.
We want to proceed in a...
Please, therefore, I didn't disturb your lordship.
Because as the issues percolate,
yes,
when the main stuff is visible, that is when you will find
Actually,
it.
basically, I am on the virus of the groups. My
Virus
facts
is
will take care of themselves. The virus, these impugned provisions are standing as a stumbling block to these 50 odd milers Venture college teachers. So I will straightway go at the virus of the.
So we'll
I
continue.
will not bother your lordship factually.
All right.
So if your lordship accommodates, my lord, allow me to address it after 2, my lord.
No, what we want to do is we have prepared, we have done this exercise with some preparation. We don't want to disturb it now because then it becomes chaotic.
Yeah,
so we'll go by this order. You can
yes.
either watch what is going on or.
Yes, we'll wait, my lord.
We'll wait, my lord.
Wait for our turn.
Yes, I think that is better.
I think
that is better. That's why I have been sitting here.
If it is taken up as the last item of the last group, I don't think, my lord, it will be coming today.
Anyway.
Right, we'll continue tomorrow. We'll continue tomorrow. But what we are saying is we will not break this seriality because we have done some homework also on the basis of this order.
That way I fit in group 2 and group 4 also. In group 4, your lordship may take up my case. Group 4.
All right. Yes. Group 4 will do it.
Yes.
Now we are in group 3, then we'll.
Yes, Lord. I'm representing other 3 petitions.
Group 3 only one case is in group 3.
Statute is there. It is gone. There is no legitimate expectation. The legitimacy of your expectation is taken away. Moment there is a statute. That's why it is not applicable.
No,
It's
no,
on
no,
a
no,
academic.
because Lordship, I am challenging this act, a proviso of this
Mr.
act.
Kalita, please consider what we are saying.
Lordship.
Once the law says you are not entitled to, there is no question of legitimacy of such expectation. That's why a statute cannot be challenged on the ground of legitimate expectation. Because it is the law which will say what is legitimate and what is not. Once the law is changed, your expectation contrary to the law can never be legitimate. But you can challenge the law on the ground that it contravenes the provisions of Constitution.
Correct, Lordship.
Or there is a lack of legislative competence. That you can do.
Correct.
But the argument of legitimate expectation, regardless of what happens in this case, it will be helpful to you for future. That can never be a ground to challenge a statute. That is because once the statute says this is right, you can't say your expectation was legitimate but still against the statute. That argument doesn't lie. Legitimacy is always clothed with the statutory provision. To have an expectation which is legitimate, it has to be legit in accordance with law.
Correct, Lordship.
Therefore, you can't say that my expectation was something else, but the law is something. So strike down the law because it is contrary to my legitimate. That argument does not lie in law. That's what we are trying to say.
Lordship,
that kind of an argument will never be permissible in law because once the law says X, your expectation towards Y is not legitimate expectation.
no, whether this X is correct or not, because that has to be looked into.
That cannot be.
In the context of my legitimate expectations.
Cannot be. That cannot be.
I'll just read out one paragraph, Lordship, for this is the latest law, Lordship, recently declared law. Lordship, this is at page 20, Lordship. I'll just take
page 20.
Page 20.
Yes.
It starts from page 20, paragraph 45 and 46. I want to read out, Lordship.
All right.
Because, Lordship, this is an evolving law.
But that's right. That's right. So you are free to argue, but then you have to develop that.
Yes, yes, Lord.
You have to develop that point.
Just small paragraphs, Lordship. At page 43, Lordship.
Yes. Page 43.
43, Lordship.
Yes, please.
So this is, Lordship, I am arguing only because it's a on the factual background as well as being a welfare state, this being a welfare statute, whether you can curtail my rights. Like not giving my expectations any respect to them.
Yes, yes, it can be. It can be. We can answer it right now. If it is done through a statute, it can be. Because Constitution permits restriction, reasonable restriction on fundamental right, provided it is expressed in the form of a law. The moment the law is enacted, all these arguments are gone. Only argument that can survive is the law is bad due to lack of competence or being in violation of the constitutional provision.
Correct.
Other things are gone. You cannot argue.
Correct.
Those arguments are prohibited. So there is no scope for this court to appreciate.
Yes, yes.
That is the way the legal principles to our understanding works. If the law was not there, then you cannot argue. Because under the law, my legitimate expectation was this. They have acted contrary to it. So protect me. That is permissible. But once the law is changed, you cannot say that my expectation is this, but law is something. So my legitimate expectation, please uphold it and decry the law which they have come in. That argument cannot lie. That cannot lie.
I got it.
Action of the state, arbitrary is one thing, and the law is bad is another thing. Once there is a law, every action taken in accordance with that is non-arbitrary. The only remedy is the law has to be struck down.
That's it.
Nothing else.
Correctly.
If the law has been struck down or read down, that's the only way out. Any law, for example, what is happening in PMLA? Just for example,
that's it.
It has severely restricted the bail rights.
Correct.
Which is totally contrary to what you have in CRPC.
Correct.
But that's the correct law because that's what law says so.
Yes, still it is.
Only way to cut it short is you have to strike down those provisions of PMLA. Otherwise, it in a way overrides supervenes the in a way, the Article 21 rights coming under the Constitution. But the bail applicant can't say that I have a legitimate expectation, because that expectation no longer remains legitimate.
Because of the act.
Once the act comes in.
I understand.
That's the point. Yes.
Only a small paragraph. Lord. The underlying basis for the application of doctrine of legitimate expectation has expanded and evolved to include principles of good administration. Since citizens repose their trust in the state, and actions and policies of the state give rise to legitimate expectations, that state will adhere to its assurances or past practice by acting in a consistent, transparent, and predictable manner. So this is where, Lordship, I'm. So principles of good administration require that decisions of public authorities must withstand the test of consistency, transparency, predictability to avoid being regarded as arbitrary and therefore violative of Article 14. From the above discussion, it is evident that doctrine of substantive legislative expectation is entrenched in the Indian administrative law, subject to the limitations on its applicability in given factual circumstances, situations. The development of Indian jurisprudence is keeping in line with the developments in the common law. The doctrine of substantive legitimate expectations can be successfully invoked by individuals to claim substantive benefits or entitlements based on an existing promise or practice of a public authority. However, it is important to clarify that doctrine of legitimate expectations cannot serve as an independent basis for judicial review of decisions taken by public authorities. That's why Lordship was pointing out that I understood, Lordship, that is there. Such limitations is now well recognized in Indian jurisprudence, considering the fact that a legitimate expectation is not a legal right. It is merely an expectation to avail a benefit or relief based on an existing promise or practice. Although the decision of a public authority to deny legitimate expectation may be termed as arbitrary, unfair, or abuse of power, the validity of decision itself can only be questioned on the established principles of equality and non-arbitrariness under Article 14. In a nutshell, an individual who claims a benefit or entitlement based on the doctrine of legitimate...
Pause here for a moment.
That's it.
The two things.
That's it.
That your expectation is legitimate.
Correct.
You can't say an expectation contrary to law is legitimate. That argument does not lie. That's why.
Yeah, I got your point. I got your Lordship's point.
So after a long and arduous argument, you will
come to that. Come back to that.
Same position.
Come back to that. That's correct, Lordship. But
Any expectation contrary to law cannot be legitimate, because legitimacy derives its etymological significance from the word legit, which means legislation, law. So you can't say that law says this, but I have a legitimate expectation contrary to law. That argument can never be accepted.
Correct, Lordship, but
these are decisions on the realm of administrative action. Action of the state, not on legislative action. We are here concerned with the legislative function of the state or the validity of an enactment, not the. They have acted as per the law.
Look, that is correct, Lordship.
Or failed to act as per the law.
I appreciate your Lordship.
The law is there, then they are correct. The law is interfered with, then they will have to accordingly adjust. So that's the point. Anyway, we have understood.
No, Lordship, my only concern was that, Lordship, since we are on the background of these cases, whether this legitimate expectation gives some kind of, because it's a welfare state, it's a welfare legislation, whether that can be considered. While bringing in this proviso, they should have considered this, Lordship. That's what my concern is. That, Lordship, other two cases, Lordship, on that. That financial
promissory estoppel.
Promissory estoppel, Lordship, I'm not placing it. I'm not placing it. Though I think the altering position and being abstained from changing my position whether it can come.
You read Motilal Padampat.
That I have sent.
And spend some time with Mr. Kencho.
Lordship,
He will tell you why your argument may not be in the right place.
Lordship, I have read it many times. But like only thing is that, Lordship, whether it's applicable to service law or not, and secondly, whether this principle can be
No,
applied.
it's not the question of that. When the state makes a promise and the other side alters his position pursuant to that promise,
Alters and abstain from.
that is one thing. But when the state brings in a law, it can go against his promise. There is no question of binding the state with his earlier promise. The law has to be struck down on the parameters which are constitutionally recognized. We are saying this again and again so that you go satisfied when you leave the court. Nothing else. If the law is upheld,
There is a learning process.
the law will be can be completely contrary to promise. There is no question of estoppel. That is why the fundamental principle is there is no estoppel against statute. Check out on that. No estoppel against statute.
But for that, Lordship, that there has to be a reason of overwhelming public welfare.
Absolutely nothing.
Recently,
That is why we want you to look into
Lordship,
this.
I'll look into that.
Absolutely, the law need not be reasonable. A statute, an enactment can be arbitrary. It is arbitrary. Many statutes are arbitrary because that is the embodiment of the policy of the state. If you are not happy with it, vote them out in the election. You cannot question a statute on the ground whether it is arbitrary or not. You can only question it on the ground of competency.
Correct, Lordship.
Or being in contravention of the constitutional provision.
Correct.
Nothing else.
Two case laws, Lordship. That
What is the point?
financial constraint.
What is the point?
Financial constraint cannot be a reason for
Question
making
doesn't
two
matter.
classes.
If the law is upheld, what is the reason we'll not go into? If
No, Lordship, they have stated that financial
no, we will
constraint
not
is
even deal with these arguments. These are, see, we are not commenting on that. There are many things which have happened. We are not commenting. How can the Secretary of the Education Department file an affidavit and say that this law is bad? A law enacted by the state legislature of the state? What authority the Secretary of the Education Department has? Starting from there, there are many things which comes into a scanner. We are not going to question. So likewise, what the Secretary says in the affidavit is hardly of any consequence in these matters. Because these are not within the remit of this court in these matters. We are only examining if these statutory provisions are valid or not.
I got it, Lordship.
Absolutely nothing else. It is not for the Secretary of a
No,
department.
that was the
That too.
correct.
We would have understood if it was a Secretary of the Legislative Assembly. A departmental secretary declares that the law is bad.
That was a stand taken by the government.
We are not questioning it because we don't think it is proper to do it. But how can he do that? Where is his authority to give you an opinion which is contrary to the competence of the state legislature?
That's
In a
what
way,
they
viewed
can-
from one perspective, this is serious undermining of the authority of the legislature. But it has happened. So likewise, there are many other things which have happened.
Well, I recently.
We are not going into the, and we don't want to make any comment. We will just go by the issue of validity of these several statutes. Mr. Barbara is waiting to address.
Yes,
elaborate
Lordship. Yes,
arguments
Lordship.
of the
Yes,
bias.
yes.
Please argue on that. We are not
Lordship,
going into who
correct,
says
so
what.
I have given this comparison, Lordship may consider it.
But
I have
we
one,
will,
Lordship.
to the hilt, we'll examine the constitutional validity of these statutory provisions. Each of them on the touchstone of constitutional parameters. So please feel free to make all arguments on that.
So that, Lordship, I have already forwarded the arguments, Lordship.
Other things are not.
These were only
Other
like
things are
supplementing
not-
to my argument, Lordship, basically.
Other things are not relevant.
I'm obliged, Lordship.
Other things are not relevant. Yes. So, Mr. Kalita, you have concluded? Anything else you want to argue?
No, that's all, Lordship. I mean, Lordship has already pointed out that, I mean, that constitutional validity of 1416 is
To the hilt.
hit
To the
by
hilt
this,
will-
that intelligible differential is not followed by classifying this. That is the whole basic argument based on that.
That is a tool.
Yes, that is a
But
tool.
the basis is violation of article.
Violation of Article 40.
That's the tool.
Correct.
We'll
That's
do
the
it.
only thing is that I was pointing out those cases because they have taken a stand. Why they have fixed those things are not in the affidavit. That's why I was pointing out. But that can be considered. Lordship may
That is
consider.
none of our, that is not the concern here. We'll look into whether this law is violative of part 3, article
Lordship.
14. whether it seeks to take away a right which was statutorily conferred, whether it abridges that, whether the state in enacting this law has exceeded its competence, the state legislature, or whether it contravenes, say from beginning, the entry, relevant entry, or any other constitutional provision, or whether it is in consonance with 2009 Act,
yes.
in which case 254 may have a role bearing. If those arguments are addressed, we'll make a note and deal with it. Individual school which has got recognition, which has not,
Those things are
those facts we cannot enter into. That will make it a unmanageable.
Lordship, I have another 3 cases in different groups. The similar arguments, Lordship, nothing else. Only thing is that like those schools are.
Which are, can you give us the numbers, please? Acha, in another category.
Another category, yes.
Then we'll.
Lordship.
Yes.
Item 43.
What is the case number? Item 43.
Me, please, Lordship.
Yes.
Also, we have already submitted a written argument. Lordship.
1 minute. Your name, please?
Jayhati Moria.
All right.
Obliged, Lordship.
Five. Item 43.
What happened to group 4?
Can I take 15 minutes time, Lord, or Mr. Morgan? As your lordship.
Why don't you decide amongst yourselves? Which is the, you're referring to any particular case?
My lord, this is 103 in
Group four,
today's course list. Actually, it falls in group 2 also.
What is the group?
No, I have challenged section 3(1), section 4. Here in my course title, section 2J, 3(1)(1), Roman 4, Roman 6, Roman 9, section 3(2), section 4. All those are already in group 2 and 4.
Yes.
And only one additional section I have challenged, section 8(6).
Yes. 2 Kimanasile J. E. Yes.
My lord, so far as the earlier division bench judgment, my lord, setting aside declaring the 2011 Act is invalid. I mean, the clause by clause violations were not necessary. There was no occasion to, my lord, adjudicate on them. In between, suddenly the concession from the government came and it was declared to be invalid and extinct. Now, my lord, at the threshold, I am submitting that this 2018 amendment has brought in certain provisions into the 2017 Act, which also are vitiated by the same virus, my lord. And these are the impugn provisions that I am challenging. If these provisions are there, these 50 lecturers of Venture Education College, all equally qualified, will never get a provincialization in their life. Either these sections remain or we remain. Therefore, I will not trouble your lordship to the factor. Facts will take care of itself, themselves, my lord. If the at least 2 or 3 offending provisions out of these 7 I have challenged.
So who are how many petitioners are here?
My lord, there are, that day, first day I argued, my lord, last week. There are 49 petitioners. These are all venture college lecturers of various colleges under both Dibrugarh University and Guwahati University. And all of them were appointed in between 1999 to 2000. Prior to 2010, all of them were appointed, meaning thereby that they were appointed prior to 2005 provincialization.
They were appointed between 1999
and 2010. I have given a chart at page annexer at page 200, my lord. And
1999
we are teaching, my lord, various subjects. At 200 is the chart.
So, Mr. Barbara, just a minute. Some of them are appointed after 2006 also.
Yes, yes. From time to time, right from 99, from time to time.
All right.
Annexer B is the chart which spells out the respective colleges that they have been serving and the subjects they are taking classes. And these subjects include both the routine subjects as well as the major subjects. Many of them have been taking up classes of the major students also. Having said that, my lord, apart from master degree holders, my lord, that day I am sorry, my lord, I was wrong. All of them are not either PhD. A few of them are not PhD and net or slate. Anyway, factually, I will not disturb. Whoever has got net or slate or PhD, that will be for the government to scrutiny. The records are there. That day I made a wrong statement saying that all of them, not actually few and not. Later on, I checked up. So we have not been provincialized as teachers or lecturers, my lord, in respective subjects, either under the since repeal 2011 Act during its existence or under the earlier 2005 Act. And although many similarly circumstanced, my lord, teachers have been provincialized over the length of time. Now, the impugn provisions are actually, which I am challenging in my petition, my lord, are standing as an absolute stumbling block. Why? Because that day I started about the repugnancy. I'll keep that aside. In a roundabout way, I will come section wise, my lord. Even a particular, instead of the whole act not being repugnant, even a particular clause may be repugnant, my lord. At the appropriate time, I will come to that. And also there is one aspect that I try to draw attention of your lordship, that suppose the Dibrugarh University Act, that is also a state act, or the Guwahati University Act, that's also a state act. That was a provincial act, 1948, existing law. If this act, 2017 Act as amended, in the absence of any overriding provision in it, contradicts the Guwahati University Acts and the ordinance framed thereunder, or the Dibrugarh University Acts and ordinance. So in that case, my lord, the assent of the president will be necessary. Because here it is saving clause, your lordship, in 2017, your lordship didn't open up the book. Normally in various state acts, your lordship has seen that there is a clause where it is written, notwithstanding anything contained in any other act, so and so, what we are saying here will prevail. This stipulation is
non-obstant clause.
Yes, non-obstant. That is not here. Therefore, the Dibrugarh University and Guwahati University prevails. Act. And Dibrugarh University and Guwahati University defines teachers, lecturers, principals, professors. You cannot have different mode of my lord describing them. That will be my first ground. Now, my lord, instead of repeating what I said last week, I straightway come to the my lord offending provisions, while my lord, while challenging the virus of section 3.1 and 3.1 and 3.2, I said the act nowhere defines what is an additional post. There is not a definition of additional post. Which post you call addition? When a post become additional post? Very often, we call geography or political science. He is the first post teacher, he is the second post teacher, he is the third post teacher, fourth one is the additional. Nowhere it is contemplated under the university ordinance or even the ordinance under UGC. What is additional post? Every subject is equal and every post in every subject is a post simpliciter. You cannot say additional. Your lordship will consider it. I'm on that. What makes the post in a particular subject, my lord? The same subject, 5 lecturers are teaching, 4 lecturers are teaching. What makes the post? If it is in order of seniority, that is also unprecedented. Some of our, my lord, the working as the second, still they are not been provincialized, my lord. Act does not specify the word provincial. It was the word additional post is suddenly brought in clause 9 of section 3.1. I'll refer to that. I have my petition, my lord. I have enacted a Gazette Act, page 232.
Yes.
My petition.
You're referring to section
Section 3.1. And section 3.1, college, clause 9. Clause 9.
that is the pre-amended or amended?
This is my lord 2018 amendment.
2018. All right.
Page 232, my lord.
Yes.
The section starts at page 231. Amendment of earlier. This is the new section. It is incorporated in the my lord compiled act with a star mark everywhere. Roman 9.
Yes.
For provincialization of services of additional teacher or tutor, as the case may be, for a particular subject, including the core subjects. This is also one word, my lord, not specified, but in the University Act, this lordship may find the word core. So additional teacher, the word additional teacher is brought for the first time in this clause. In the definitional clause, teacher is defined, everything is defined, tutor is defined, additional teacher is not defined. Now for here, lordship will kindly see. I am reading Roman 9. For provincialization of services of additional teacher as tutor or tutor, as the case may be, for a particular subject, including the core subjects, in addition to the post mentioned in section 3.1.4. I will go to that. Then oblique, my lord, this clause will have to be conjunctively and disjunctively read, my lord. In, lordship may put a bracket, in any venture high school, this is not applicable. This sentence is not applicable. Go to the next page. Leave the first. In addition to the post 3.1.4, and comma, in a venture degree college, where I am, my lord, the minimum students appearing in the last final examination of the class, that particular subject must be more than 150. I read it again, my lord, leaving the disjunctive part, my lord, here. I read it like this. For provincialization of services of additional teacher or tutor, as the case may be, for a particular subject, including core subjects, in a venture college, the minimum students, then I'll come to the last sentence. In a venture college, the minimum students appearing in the last final examination of the highest class for that particular subject must be more than 150 for one additional post. So in case of venture college, it says for provincialization of service of additional teacher in any subject, the minimum students appearing in the last final examination will have to be 150. This is, my lord, 150 figure. It is absolutely absurd, irrational, arbitrary, and unrealistic. It is also, my lord, contradictory to or intravirus or ultravirus to the preceding subclause, that is Roman 7. Let me come to the previous page. What Roman says, Roman 7 says. Here it says, for provincialization services of one teacher or tutor, as the case may be, in subject including core subject, then it goes. Then come to the last sentence. These are madrasa, venture, senior secondary. Then last sentence. In case of a venture degree college, at least 15 students in that particular subject must have appeared in the last final examination of them. Here they say, I'm reading it again. Clause 4, clause Roman 7. Here it says, for provincialization services of one teacher or tutor, in as the case may be, in subject including core subject, in case of a venture degree college, at least 15 students in that particular subject must have appeared in the last final examination from the college. Well, there you said 150. Here you are saying 15. And senior secondary classes are also there in some of these venture colleges, my lord, as well.
No, the second part, Roman 9 is for additional post.
Additional post.
And the Roman 7 is not for additional post.
Not for it, say tutor or teacher. So my question is, why some drastic condition is imposed even to become an additional post provincial? 150. There I is, my lord, I will come. That it is unrealistic, it is irrational to expect 150 students appearing in the last final examination. That day, I have shown the prospectus of the leading colleges of Guwahati, Bipura College, Pragyutis College. It is there in the records plan. Yes.
No, but Mr. Barber, just pausing for a moment. See, we are really looking for some weighty assistance which you are capable of.
I am still learning.
No, that's all right. Mr. Chaudhary has argued, Mr. Anjan Kalita has advanced elaborate arguments, and others have also argued. But what we wanted to know very clearly at the outset, there are several grounds urged, and we have been mentioning again and again that in these proceedings, we will possibly examine only the constitutional validity of these statutory provisions.
That is what I am attacking.
Now, is irrationality in making law a ground to strike down a law? Is there any such?
It can be. It can come within the ambit of violation of Article 14, my lord, I will show. If it is, my lord, absurd, my lord, if it is, my lord, impracticable, unrealistic, my lord, why? Because UGC says 1 teacher, 30 students ratio. There is a parent provision, not this. So I, my lord, that they produce the, and also I'll come to the statutes. These prospectus are there. There I have known that there. If it is there in the file, also may still have a look. It is, my lord, Pragyutis College. Here, my lord, the number of seats. BA. Anthropology 10, Assamese 40, Bengali 10, it's all right. Bodo, Economics 23, here in the honors major, Mathematics 2, Philosophy 25, Political Science 30, Sanskrit 20, Statistics 2, Education 30. So, we can't expect that from this college, there will be in the last final examination, there will be 150 students. In giving exam, last final. Similar is the case. Statistics 10, Geography 15. Total number of seats, my lord, How can there be, my lord, examinees crossing even 50? Total number of seats available in this college for anthropology is 15. For economics, honors 10. Similarly, in the Pandu College, more or less the same picture. These prospectus, these are the prospectus, my lord, of 2020, 21, 22, 23, like that. After DJAC. Here again, Lordship will find not a single subject, barely one subject, education 50. All others are less than 50. Both in the science stream subjects and in the arts stream subject. Number of seats available in various disciplines. So nowhere it crosses 50 in any subject. Similar is the B. Borua College. Honors seats, science plus arts, chemistry, mathematics, English, of course, there is 60 at one place. But other subjects, political science, history 30. So therefore, I have also so it falls sort of, it doesn't tell you the 1:30 ratio also. Then, my lord, I'll take your lordships, the students, the statutes on affiliation of old and new colleges. Dibrugarh University gives the affiliation to my college where I am and also the Kanai College. Guwahati University, one is from Bilasipara College. Affiliation is given to some of my petitioners, and the affiliation of Pandu College and all these colleges are under Guwahati College, Guwahati University. Only Cotton University has now become a self-made university. Doesn't have to get affiliation for undergraduates in Cotton College. Who invested today? Dibrugarh University. এখন দিয়া আছে নাই না? So that day I also placed before your lordship an ordinance statute of Dibrugarh University. It should be on the records. Man, 2 copies I gave. So no. Oh, otherwise I have. I can explain.
You're referring to this?
Yes, yes. Dibrugarh University. I have.
One copy is here.
Huh? Dibrugarh.
We only one copy, all right.
Yeah, Dibrugarh I have.
Make 2 copies.
One copy আছে,
Yes.
এইটো আমাক লাগিব নহয় ফটো কৰি জেৰক্স কৰি দাগ মৰা নহয় হা ও লটস can have this one also Dibrugarh.
All right.
Lordship, kindly have a look here. G is called page 26. G, colleges with pass course plus first, second, and third year honors class. Arts and commerce, 4 lecturers in each subject except in English and any other language subject in which there shall be at least 5 lecturers. So the university itself prescribes that there will have to be 4 teachers per subject. And you say first, second, third, whoever comes at the 4th with equal qualification, he will be additional. You cannot do that. Subject to whatever your lordship derive, I think I am clear on that. Then here next page, my lord, 18, it was 18. Irrespective, this is just extract from this, my lord, statute. It's a huge statute. Irrespective of other requirements, page 27. Irrespective of other requirements, the total staff student ratio in a college should not be less than 1:30. So that is where you should be mindful about. Not insisting that there must be 150 students who must appear in the last final examination. Otherwise, you are not provincialized. Teach for how many years you wish. Then, my lord, in a situation, Guwahati University. So in a situation, my lord, imagine a situation in a given year, say the number of enrollment of students, enrollment cannot be more than the seat earmarked by B. Bora College or any other college, Demaji College for that matter. When we say there are 19 seats, we cannot give admission to 21 students. In a situation, my lord, imagining in a given year, suppose the number of enrollment and number of students appearing in last final examination as mandated by, my lord, these clauses decrease, then do you provincialize the subject wise post? The next year, if it decreases, do you deprovincialize? In the event of certain dropouts or non-appearance in exam, you penalize the teacher that so many students have not appeared in your subject in the last final, therefore you are deprovincialized. Guwahati University Ordinance. My lord, that day I said the acts, my lord, of the Guwahati University and Dibrugarh University, the acts as they are, they don't provide for, my lord, staff pattern and all this. These are provided for under the statute and the ordinances, like UGC Act also under the regulations and time to time guidelines. So these ordinances are also yeah. Now, my lord, these ordinances or, my lord, statutes, they are also laws within the meaning of Article 13(3)(a) of the Constitution of India. If this provision, particular provision, is against the repugnant with respect to the Guwahati University provisions, the ordinance will do. Not essentially that the University Act, it has to go against the University Act. Act doesn't provide for all these things.
You are referring to this?
Yes. That is also under the Constitution by Article 13(3)(a) of the Constitution says that ordinances, statutes, even bylaws under the Parent State Act are also laws. I'm making that clear, my lord. So they are in violation of that. Then, my lord, Guwahati University, that also I have given that day. Should be there. So now, network লাই যাব না? This is ordinance on permission and affiliation of degree colleges to the Guwahati University, 1997. Here, the minimum requirement of teaching staff for 3-year degree courses. We are all affiliated colleges. We are under Dibrugarh, affiliated by the jurisdictional university. Demaji College under Dibrugarh, Bilasipara College under Guwahati University. Now there are too many universities also. The minimum requirements, as a lordship got that, Guwahati University.
Yes, yes.
Here, my lord, here also page 19. Minimum requirements of teaching staff for 3-year degree course. Lordship, kindly see BA General plus Major. Up to first year, 2 teachers. Up to second year, 3 teachers. Up to third year, 4 teachers. Then again, BSc General plus Major. 2 teachers up to first year, 3 teachers up to second year, and third year, 4 teachers. Recently, system. So therefore, these 2 university ordinances and statute, what they provide is irrespective of number of students enrolled or number of students appearing in any examination, this is the staff pattern. And you are squarely violating it. No post is a lesser post. No post is a lesser post. Physics, be it anthropology, be it geography, be it minor mathematics. Posts are post simpliciter. Now, prior to 2011 Act, since repealed, in 2008, the government had circulated the staff pattern for the degree colleges in Assam, which your lordship will find at page 234. This was by the Director of Higher Education, December 18. Subject, it is circulated to various colleges and director.
Page number?
Page number, the last page of my petition, 234. Annexer. Here, the subject itself is, it is issued by the Director of Higher Education, dated 18 December 2008. Staff pattern of degree college. With reference to subject, I have the honor to furnish the staff pattern of degree college as follows. For arts stream, now kindly see, as per Guwahati University Ordinance 97, it is mentioned. The one I have produced. Till then, they were going by that. 2018, they had no idea, new ideas. Here, lecturer 3-4 pass course plus 1-4 major course, 4. No postage additional. cannot be additional. Now, my lord, after introduction of NEP 4 years course, in the other day it has been introduced. Now it is NEP 4 years. So number of papers in subject, every subject increased. Now. NEP I know. And here a relevant clause in my lord.
What is NEP? NEP?
New education policy. Now it is 4 year degree, my lord. So we more papers. 3 years, my lord, suppose there are 9 papers, now it is 12 papers. In fact, there are 26 papers, I am told. Now here, your lordship, a relevant clause of the clause will be 3.2. That is page 213. I have impugned this also, no? 213. The gazette notification. Tarun Sutier's compilation is good, but binding is bad. Horrendous. I am going by the gazette notification. Compilation is good. Nice service. Here, your lordship will find 2013. It starts 3.2. Your lordship will file at 2014. Yes. It is under clause 3. 3.1 is the preceding page. 3.2 top. In case of a venture degree college and a venture higher secondary school or venture junior college, the eligibility criteria in subject eligibility criteria in subject criteria specified in subsection above, my lord, I have shown, regarding date of recognition, affiliation or concurrence, minimum enrollment and performance would mean in respect of each of the subjects with or without measure as the case may be, and the services of the teachers appointed or engaged in connection with such subject or subjects shall be considered for promotion, provincialization under the provisions of the Act, only if specified eligibility criteria as per University Grants Commission Act, National Council of the Teachers Education Act, and the relevant rules and regulations framed thereunder, as the case may be, as applicable to the date of provincialization are satisfied, and having sufficient enrollment in the concerned school or colleges including. Now, my lord, here, the word sufficient is a vague and unspecific word. What is sufficient? At one place you say 15 students will do. At one other place you say 150 students must appear in the last final examination. It cannot be elaborated by insertion of the provision like 3.1 Roman 7 or 9, prescribing, my lord, the arbitrary and superimposed figures like 15 students. How sufficient it is, I don't know. Your lordship doesn't know. And 150 students appearing in the last final examination. So hereby I am submitting, my lord, in my limited capacity, that you are defying UGC 1:30 ratio, you are defying Guwahati University, you are defying Tribunal University, you are putting your own formula and calling somebody working in the fourth post as an additional teacher. The university and university as a teacher in every subject, provided he is a qualified, we are qualified. This petitioner number 1 is a doctorate. So you cannot.
So they are the petitioners, their services have not been provincialized.
Not been provincialized.
So they are working as private.
Working, teaching. Now, my lord, this is absolutely, my lord, section 3.1.1. It is, my lord, absolutely unreasonable classification without reasonable differentiation, my lord. That you classify teachers like this, post simpliciter as opposed to additional post, these are unreasonable classification, basically. Those things were not discussed in the, my lord, division bench judgment earlier, because I had no occasion to discuss. And I will invite your lordships to discuss. On unreasonable, I think one decision was cited, my lord, that was the post-independence first major decision, my lord, 7 judges, year 1952 Supreme Court, West Bengal versus Anwar Ali. This was the first case where, my lord, classification was discussed. It is a 7 judge, 6:1 ratio. Patanjali Shastri Chief Justice, he was the minority view, rest 6 judges, Fazal Ali, MC Mahajan, BK Mukherjee, S.R. Das, Chandrasekhar Iyer, and Vivian Bose, majority.
It is there in that volume given
Is
by
there?
Mr. Venkat College.
I'm supplying this online edition, my lord. I'll just refer to few paragraphs. It's a long judgment. Here the minority view, for the minority view of the Chief Justice, his lordship was the only minority view. Paragraph 9. Thus, the general language of Article 14 as American counterpart has greatly qualified by the concession recognition states regulative power to make laws operating differently on different classes of persons in the governance of the subjects, with the result that principle of equality of civil rights and equal protection of the law is only given as to the safeguard against the arbitrary state action. It follows that in judging a given law as discriminatory and unconstitutional, two aspects have to be considered. First, has to be seen whether it observes equality between all persons on whom it is to operate. An affirmative finding on the point may not, however, be decisive on the issue if the impugn legislation is a special law applicable only to a certain class, not in my case. Having regard, thus the reasonableness of classification comes into question only in those cases where special legislation affecting a class of person is challenged as discriminatory. Then his lordship, it was, my lord, the first special court act, West Bengal Special Court Act. The challenge was, my lord, the certain section of West Bengal Act 1950, where two classes of offenders were sought to be created, classified, 2 classes. And there, my lord, ultimately, when the matter came to the Supreme Court on an appeal by West Bengal government, my lord, this was the judgment rendered. Here, his lordship said, paragraph 20, such classification need not be based on an exact of scientific exclusion or inclusion. I cannot share the view of Das Gupta. Then, next page, my lord, your lordship will straight away, I will not read too many passages. Paragraph 41. It is Fazal Ali, majority, one of the majority, paragraph 41. Paragraph 41, it was suggested that good faith and knowledge of existing conditions on part of a legislature has to be presumed. That is so, yet to carry that presumption to the extent of always holding that there must be some undisclosed intention or reason for subjecting certain individuals to a hostile and discriminatory legislation is to make the protection clause of Article 14, in the words of American decision, a mere rope of sand, in no manner restraining state action. The protection afforded by the article is not a mere iOS, but it is a real one, and unless a just cause for discrimination on the basis of a reasonable classification is put forth as a defense, the statute has to be declared unconstitutional. No just cause has been shown in the present instance. In the result, the appeals failed. This was by Fazal Ali, then the other majority view by Justice BK Mukherjee, your lordship. I skip this. Did the appeals fail? Then SR does per majority. Here, my lord, I will read paragraph 58. Last portion of the paragraph 58. last 6-7 sentences. So paragraph 58. The classification must not be arbitrary but must be rational. That is to say, it must not only be based on some qualities or characteristics which are to be found in all the persons grouped together and not in others who are left out, but those qualities or characteristics must have a reasonable relation to the object of the legislation. In order to pass the test, two conditions must be fulfilled, namely that the classification must be founded on an intelligible differentia which distinguishes those that are grouped together from others, and that differentia must have a rational relation. Here the question of rationality comes, my lord. Lordship was asking me that question. Rational relation to the object sought to be achieved by, what do you want to attain by saying that no, there will have to be 150 students? Is it a rational? Can it be called a rational relation to your object? No. The differentia, which is the basis for classification, and the object of the act are distinct things, and what is necessary is that there must be a nexus between them. In a short, while the article forbids class legislation in the sense of making improper discrimination by conferring privileges or imposing liabilities upon persons arbitrarily selected out of a large number of other persons similarly situated, like us, excluded, in relation to the privileges sought to be conferred or the liability proposed to be imposed, it does not forbid classification for the purpose of legislation, provided such classification is not arbitrary in the sense I have just explained. Then last paragraph. Then the appeal was dismissed by these lords. So this, my lord, 1952 judgment, and the last is at page 88. Here also I am coming first 88 paragraph of last 4 sentences around from left hand side below paragraph 88. If the act does not enunciate any principle on the basis of which the state government could select offences of class of offences or classes of cases, and the state government is left free to make arbitrary selection according to their will and pleasure, then the act is void. On this point, I would invite special attention to the view of Justice Dasgupta in the following passages. The Act lays down no principle on which selection or classes of offences or classes of cases should be made by the state. State may even arbitrarily determine the classes of cases to be tried by a special court, and if it does so, its action will be well within its powers conferred by Act. The Act indicates no basis whatsoever on which such classification should be made. I am of the opinion that the whole Act is ultra vires. Then Vivian Bosmailer, these were legendary names. Then last page, 106 paragraph. Tested in the light of this consideration, I am of the opinion that the whole of the West Bengal Act offends the provisions of Article 14 and is therefore bad. When the fourth and the form of discussion is cleared away and learned dialectics placed on one side, we reach at last the human element, which to my mind is the most important of all. The human element shouldn't be forgotten by any welfare state. We find accused heinous crimes called upon answer for the lives and liberties. We find picked out from their fellows. And however the new procedure may be given to them a few cramp of advantage, in the bulk, they are deprived of substantial and valuable privileges of defense, which other similarly charges are able to give. Then it said, it matters not how lofty and laudable the motives are. The question with which I charge myself is, can fair-minded, reasonable, unbiased, and a resolute man who are not swayed by emotion or prejudice regard this with equanimity and call it a reasonable, just, and fair. Regard it as that equal treatment and protection of the defense of liberties, which is expected of a sovereign democratic republic, a condition in which obtained. I have but no answer to that. On that short and simple ground, I would decide and hold the act valid. Now, 70, almost 75, 70, more than 70 years have gone. After this judgment, this still holds the field. And all other cases, yours, old is gold. All other cases, I have a list, my lord. I will not disturb. And I have heard some of my lawyers friends also are good on unreasonable classification and read out the judgment. But this is the father of all. 7 judges. Then, my lord, here I also just 1 5-judge judgment. Here, my lord, 83 Supreme Court. D.S. Nakara, I didn't read that. Just one paragraph I'm reading. Hello. Motu kuntu? No, I don't know. Yeah. It is even there. Here I'll refer to paragraph 12. Yes. Reading from my book, the old marks are there. I relied before various courts. Paragraph 12. It should tell you. Paragraph 12, my lord. After an exhaustive review of almost all decisions. After an exhaustive review of almost all decisions bearing on the question of Article 14, this court is speaking through Chandrasu C. Jaisenior in Ray Special Courts. Restated the settled propositions which emerged from the judgments of this court, undoubtedly, insofar as they were relevant to the decision on the points arising for consideration in that matter. 4 of them are apt and relevant for the purpose. They are constitutional command to the state to afford equal protection of its laws sets a goal not attainable by the invention and application of a precise formula. Therefore, classification need not be constituted by an exact or scientific exclusion or inclusion of persons or things. The court should not insist on delusive exactness of applied doctrine tests for determining the validity of classification in any given case. Classification is justified. It is not if it is not palpably arbitrary. If it is not palpably arbitrary. Principle underlying the guarantees of Article 14 is not that the same rules of law would be applicable to all persons within the Indian territory, or that same remedies should be made available to them irrespective of differences. It only means that all persons similarly circumstanced shall be treated alike, both in privileges conferred and in liabilities imposed. That's what the 7 judges said. And there should be no discrimination between one person and another if as regards the subject matter of the legislation, their position is substantially the same. MMA, net slate, or PhD. Check. Subject is the same curriculum I teach. And a provincialized teacher, already provincialized. Teacher is the same. 4. Principle underlying guidelines guaranteed for to Article 14 is not that the same rules of law should be applicable to all persons. This I have read. The law can make and set apart the classes according to the needs and exigencies of the society, and as suggested by experience, it can recognize even as a degree of evil, but the classification should never be arbitrary, artificial, or evasive. The classification must not be arbitrary, but must be rational. Here again, the question, my lord, rationality is coming. It has to be rational. I am not asking your competence to legislate, but you must rationally legislate it. If in the judicial scrutiny of the Constitutional Court it's found that you have not applied rationality, then court will interfere about the validity with regard to. Classification must not be arbitrary, but must be rational. That is to say, it must not only be based on some qualities or characteristics which are to be found in all the persons grouped together and not in others who are left out, but those qualities or characteristics must have a reasonable relation to the object of the legislation. In order to pass the test, 2 conditions must be fulfilled. Namely, that the classification must be founded on an intelligible differentia which distinguishes those that are grouped together from others, and 2, that differentia must have a rational relation to the objects of to be achieved. Then paragraph 13. The other facet of Article 14 which must be remembered is that it eschews arbitrariness in any form. Article 14 has therefore not to be held identical with the doctrine of classification, as was noticed in Manaka Gandhi. In the earlier stage of evolution, Article 14 came to be identified with the doctrine of classification because the view taken was Article 14 forbids discrimination and there will be no discrimination where the classification making the differentia fulfills the aforementioned 2 conditions. Then it mentions about RAP and quotes therefrom. So, paragraph 15. Thus, the fundamental principle is that Article 14 forbids class legislation but permits reasonable classification for the purpose of legislation, which classification must satisfy the twin tests of classification being founded on an intelligible differentia which distinguishes persons or things that are grouped together from those who are left out of the group, and that the differentia must have a rational nexus to the objects sought to be achieved by the statutory question. So these provisions and principles of grouping, not based on any rationality, arbitrarily classified, these principles and the view of the Constitution as spelled out by lordships from time to time still remain, and they are safe. Then one last case on this 1989 volume 2 SCC. This is Punjab University Depot. Yeah. Huh? This is 89. Did I answer you? 1989 2 SCC 145. Sorry, I have the book. Hmm? Anyway, then, my lord. I'm sorry. Here they are. Online copies are not brought, my lord. This case was also cited. Here, my lord, it is Deepak Sibal versus Punjab University.
We've seen that.
Only a few paragraphs. I am reading. Paragraph 9. I am reading, my lord. Sometimes giving rest to your lordship's eyes is also good. Only by hearing and not looking at so many pages, my lord. Let me take up the trouble of reading, my lord.
Thank you.
It's now well settled that
We can't promise you return gift, but thank you for giving us the relief.
I am reading paragraph 9. It's now well settled that Article 14 forbids class legislation, but does not forbid reasonable classification. Whether a classification is permissible classification under 14, two conditions must be satisfied. One, that the classification must be founded on an intelligible differential which distinguishes persons of things that are grouped together from others left out of the group. They are just now the others. These are followed. That the differential must have a rational nexus to the objects of to be assigned. Then paragraph 10. By the impune rule, a classification, that was, my lord, it was discussing about Punjab University rules. By the impune rule, classification has been made for the purpose of admission to the evening classes. I think this was cited by one of my friends yesterday. Maybe Goswami's case. That's why I remember. I was sitting there, I was listening, waiting for my thing. It should be there, day. Is there?
Is there?
Okay, I'm reading. By the impune rule, a classification has been made for the purpose of admission to the evening classes. The question is whether the classification is reasonable within the meaning of 14 of the Constitution. In order to consider the question as to the reasonableness of classification, it is necessary to take into account the objective for such classification. It has been averred in the written statement by Dr. So-and-so, Chairman, Department of Law, Punjab University, filed High Court, that object of starting evening classes was to provide education to bona fide employees who could not attend the morning classes on account of their unemployment. The object, therefore, was accommodate bona fide employees in the evening classes as they were unable to attend the morning classes on account
Mr.
of.
Cobra, we have seen that.
The
court
So,
says there is not.
government employees and public employees, private employees, you cannot distinguish. You cannot make different. You cannot exclude the others. So that also goes in my case. Right. So this again is, then I will come to my lordship, the virus of section 311. So long I was arguing on my lord 3.1, Roman 4 and Roman 9, my lord. 150 students. And to call it an additional post, contrary to Dibrugad University. University never say subjects are subjects, simply say major or minor, and post are post. Then on section 311, this is another subsection I have impugned. In my petition,
Yes.
Mr.
Chakraborty, looks difficult.
One lawsuit has wanted one clarification, whether from the senior case anybody has been promoted or that instruction. Otherwise, argument is complete.
No, we are yet to hear the other side. Yes.
Page 211. Section 3.1, eligibility criteria for selection of educational institution for provincialization of services of teachers or tutors. In my petition, my lord, it's page 211.
Yes.
The venture educational, subject to the provisions of Section 30 of the Constitution of India, the following categories of, this is minority, the following categories of venture educational institutions shall be eligible for being considered for provincialization of the services of their teachers and tutors. The venture educational institutions which have been established and had obtained the required permission, recognition, affiliation, concurrence, as the case may be, up to the last and highest class required for that concerned institution from the respective competent authority or authority on or before 1/1/2006. Now, I would say that by this provision, an absolutely arbitrary manner and irrational manner, a shutters down postulation has been prescribed. Shutters down, no further, not beyond. Stay at 2006. Why? It fixes a cut-off date, my lord, of 1/1/2006, and I will respectively endeavor to convince your lordship that this is a superficial cut-off date. Why at 1/1? Why it is relevant? What significance it has got? Statutory significance. It fixes a cut-off date of 1/1/6 for any venture college which obtain concurrence, affiliation. Concurrence is always from the government and affiliation is from the university. For the purpose of provincialization under this act, this is also, my lord, both ultra-virus, unconstitutional for a number of reasons. Number one, it puts an embargo on the fundamental rights of people to open schools. The Empire case. All citizens, any or a group of citizens can always open up a school. You will have to abide by governmental norms, jurisdiction. On a piece of land. Must meet the infrastructure requirements, must meet the fee structure. These are different things. Held by Supreme Court, my lord, that right to open established educational institution, but it brings out, therefore, this section 311, it brings out or tends to bring a stagnancy in the increasing and ever-growing field of education. Well, 2016, we are 18 years ahead now. Venture colleges established in the, my lord, remote areas to enable youth to undertake education in a radius of 220, maybe 15 to 20 kilometers, there is no college available. Now, amended section 2W was retrospectively brought in. It brought in, my lord, the superficial cut-off date of 1/1/2006. I will invite your lordship to have a look at 2W at page 231. Yes. Hmm. 2W Sage 231. Venture degree college means a degree college imparting education beyond higher secondary stage established by the people of that locality prior to 1/1/2006 and which has also received affiliation from the concerned university, concurrence from the state government on or before 1/1/6, at least for TDC Part 1, and whereof services of teachers have not been provincialized under the act enacted by the state government so far. Now, there are government circulars of 2019 after the 2018 Amendment Act the government brought in. Government also issued circulars. Hey, out of copy dinner. 7 March 2019.
7 March.
By Director. Circular, government memorandum. This is up to 7th of March 2019, my lord, after the Amendment Act. The government office memorandum, so and so, February 2019 regarding guideline for according no objection for opening a degree college, new subjects, major subjects of study in degree college, and granting permission to affiliation accorded by universities enclosed herein. Colleges applying for permission, no objection for opening of a degree college, introduction of new subject, major courses, degree college will be considered as per the terms and conditions of the government. I mean, if now I apply for affiliation and I concurrence, government goes on allowing new institutions on the one hand and yet put a cutoff date and shutters down date of 1/1/2016. It's absurd, my lord. No nexus with the objects of the act. The next office memorandum is regarding guidelines, my lord. No objection for opening a degree college. Definitely there will be certain requirements college will have to meet. But the things remain that you government, even after the 2018 Act amendment, you are going on allowing new institution on the one hand and giving no objection for opening a degree college. And also, you said that you will be considering as per terms and conditions of government's new guidelines. This also goes to show that the date 1/1/2026 is irrelevant, statutorily relevant, and you cannot prescribe a cutoff date like this, reading with 2W. Then, my lord, while inserting this 1/1/2006 cutoff, this legislation, this enactment has conveniently, my lord, inserted to 1/1/2006 by being absolutely oblivious to what section 2J says. Now have a look at 2J. Your lordship will find it page 217. No, I think the page is 2J. I got us. (206), lordship.
Yes.
It says employee. Employee means and includes all serving teachers and tutors, as the case may be, of venture educational institutions who have been appointed and joined in the concerned venture educational institution before the first day of 2011 and whose services are being or would be provincialized under this. Is it like elastic? Here you are extending it to 2011, and there you say cutoff date is 1/1/2006. Intravirus, self-incompatible with one provision to the other. Both intravirus and ultravirus. I am again reading. All serving teachers, employee means and includes all serving teachers and tutors, as the case may be, of venture educational institutions who have been appointed and joined. Now, can you see the chart? Our particulars, all these 50. We have given the chart, date of joining and date of appointment is there. Who have been appointed and joined in the concerned Venture Education Institution before first day of 2011 and whose services are being or would be provincialized. So 2J keeps upon provincialization of employees and teachers appointed and joined in a venture college much after 1/1/2006. In fact, some of the petitioners in my petition also somewhere of 1999, 2001, 2002, some of them are maybe 2007, 8, 10. 10 is the
Is
last.
there any specific document to show the date of joining? Any specific document in the report?
I have the orders, my lord. I crave leave. The chart is there. That way, my lordship will be going into the facts. I actually don't want to trouble your lordship.
That's fine, that's fine.
I have the particulars, certificates.
All right.
So 2J keeps upon provincialization employees like this. Now, giving affiliation to college by the concerned jurisdictional university, whether it is a Silapata or it is a Tangla or Margarita, it is a continuous process. Once the process is still on under the University Acts, you cannot put an embargo with a cut-off date of 1/1/2006. If the university under the University Act gives me affiliation today, should I come under 1/6 and bad? Education is a continuous process. So you cannot put an embargo. This is self-defeating. This is self-defeating, contradictory, intra-virus and ultra-virus with no plausible nexus with the object sought to be achieved by the government. Now again, my lord, I refer to section 4(2) clause Roman 3 at page 217 related to this point.
Yes.
I am reading section 4. This section 4 has also been challenged by a cluster of petitions in this series. Section 4. Subject to fulfillment of all other provisions of this Act, page 216. Subject to fulfillment of all other provisions of this Act, the services of teacher or tutors of all venture educational institutions eligible under section 3 shall be deemed to have been provincialized on the date of publication of the provincialization order by notification in official gazette, and they shall become employees of state government with effect from such date. Good, fine. 2, the teachers and or tutors to be provincialized under the must have been working as a teacher in the concerned venture educational institution that have been fully recognized up to the last and highest class required for such institution by the competent authority on or before 1/1/2006. Here again 2006. Then Lordship may go on reading. Next, Roman 2. Must have minimum educational and professional qualification as laid down under different acts, rules, and regulations as mentioned under section 6 or any other relevant statutory provisions as the case may be. Then 3 is important. Must have rendered at least 6 years of continuous service as on 1/1/2007 from the date of joining in the concerned venture educations, which must be on 31/12/2010 or prior to that. Now, here is another contradiction. If I complete 6 years of service by 1/1/2016, then it will be good enough for me that I joined in 2011 and not your 1/1/2006. Am I clear? See the postulation here, Roman 3. What is the requirement? Here in Roman 3, you say that I must have rendered at least 6 years of continuous service as on 1/1/2017. Meaning thereby, if I served continuously since 2010 to 2017, 1st January, I have already completed more than 6 years. You cannot insist on 1/1/2006. So that is why I said that the purported statutory requirement and cutoff date of 1/1/2006 is per se ultra-virus, intra-virus, and you cannot put a shutter like this. By putting a shutters like this, you are encroaching upon the fundamental rights of these venture colleges and the teachers. Now, I will, my lord, again take your lordship to the earlier division bench judgment for 2 or 3 paragraphs. Because it was a breakdown type of situation where the case ended. Actually, arguments could have gone clause by clause in that case. But there was no occasion because in between government came up with an affidavit of admission. Yes, it is repugnant. The whole act is repugnant. Therefore, so it was, with all respect, it was nothing much works left for the division bench. There, everything ended. You admitted expansion, repugnancy. Well, like your act is invalid. So the nitty-gritties of the 2011 act actually were not examined, and there were actually no occasion to certain sections. Here, my lord, therefore, let me see what were some of the submissions and the grounds that we could find from this judgment. GLT, my lord, this is Sunderneut's case, GLT 2016, volume Roman 5. GLT.
Which decision is that, Mr. Babu? Which?
This is, my lord, GLT 2016. I said, it is there, my lord. It has come. This is the judgment of the division bench.
Yes. Yes, please.
Here, my lord, I'll be reading. I am reading this judgment just to show that the 2017 Act as amended by 2018 has not removed the infirmities pointed out by the division bench or by the council appearing there in raising their grounds for challenging 2011 Acts, my lord. And in order to show your lordship that just this impugned 2017 as amendment Act with these impugned provisions are just old wine in new bottles.
So which are the infirmities pointed out by the division bench? Paragraphs?
My lord, paragraph 11.
Yes.
It is recorded by his lordships, their lordships. Paragraph 11, the petitioners contend that if employment planning is the state's objective in stipulating the cap, the state policy must nevertheless be shown to be a rational one.
No, but these are all submissions.
Submission, but the court, that's what I was saying. These could not be pushed through to a logical, judicial conclusion, my lord. This was ours. So to show that I am also arguing it here before your lordship, that it will not be sufficient for you to say that now, as per state policy, we are doing it. Your state policy has to be rational. And then, my lord, paragraph 34. And paragraph 15 also, your lordship may have a look. Stipulation of the cutoff date of appointment prior to that was appointment prior to 1/1/2001 is contended to be illogical, as there can be no rational basis to distinguish those who were appointed before and after the cutoff date as both categories under the same service in the respective institutions. Therefore, it is argued that all serving employee on the date of enactment of the Provincialization Act should be considered eligible for provincial. That was one of the arguments. That was one of the grounds taken. Then paragraph 34. Yes. After quoting, unquoting, my lord, the affidavits filed by the state conceding. Paragraph.
Just a minute, Mr. Prabhu.
Okay. মোৰ ফালে লেঠা আছে অলপ যিমান পাৰি গৈ লওঁ আৰু সদায় যাবলৈ চাকিত তেল দিয়া নাই ঘৰটোৰ নিচিনা
Yes, yes, please.
Paragraph 34, my lord. But this litigation is their lordships. But this litigation reveals the non-application of mine, and it is all pervading in the state act. The discriminatory impact of the Provincialization Act is found to be glaring here, irrespective of concession, his lordship's observation, irrespective of government affidavit. Found to be glaring here. In order to avoid impermissible discrimination, the classification must be founded on an intelligible differentia which distinguishes persons or things that are grouped together from other left out of the group, and also the differentia must have a rational relation. The word rational, I have been showing in the other cases also. Rational relation to the object sought to be achieved by the statute in question. Petitioners here project that their teachers whose services are provincialized and those who have been left out are at par in all aspects. In most cases, both categories have been rendering service in the school since inception and are similarly qualified as well as rendering similar duties. There is nothing on face of the statute or surrounding circumstances to show any distinguishing factor. Also, no rational relation of such differentia with the object of the Act is discernible from the reading of the provision. In fact, the object of the Act is to provincialize the services of teachers in venture education institutions and prevent further growth of such institutions. However, the object of provincializing services of the required teachers in the institutions established bona fide stands negated by the enactment of the present same. This is the last paragraph I am citing, 35. The venture schools which were set up bona fide on need basis, in our perception, do serve the students in remote places, and it may not be wrong to say that due to the inability of the state to discharge its continual obligations, the venture educational institutions were allowed to function. Because when it all started, my lord, after independence, you government from Sadia to Dhubri, you couldn't open up, my lord, the requisite number of government schools.
So and venture educational institutions have not come up after 2017. They're not coming up even now. No.
Permissions have not been granted or
No, but
applications have not been.
this notification of 7th March 2019 says.
This is Lossi in respect of existing colleges, Lossi. To those colleges whose service of college are provincialized under the 2005 Act, Lossi. They are, if they wants to, Lossi, open an additional stream, say, Lossi, there is a arts and science stream is there. Now they are wants to open a.
Language of the circular, Lordship.
That is the purpose, even commerce.
What the circular says.
In the existing colleges, Lordship, not in the 2000.
That is not written there.
No, that is not, but in any case,
Lordship,
we have also noticed just a small clarification.
Lordship.
It is mentioned in the object clause of both the previous as well as the
Lordship,
later act.
Lordship.
One of the objective is to stop the further growth.
Lordship.
Which provision in the act stops further growth? Which is that provision in the act?
Lordship, that part, it is 2006 of the
There must be some provision. which
Lord,
says
that
there
is
will be no further. Which is the provision?
2006 of the no, It is in respect of non-government college management rules, Lordship.
No, but the 2017 act says
Lordship.
one of the purposes, one is to provincialize.
Lordship,
and other is to stop mushrooming or
Streamline.
Lordship.
streamlining is one of the purpose.
Lordship.
And other is to stop
For further, Lordship,
further,
further opening.
which is the provision in the act which
Mm.
aims to achieve that objective. That's what we are saying.
That's what, yes,
Which provision is there?
Yes, it is there. Lordship, will provide, Lordship.
Just
It is,
let us know.
it is there, Lordship.
Paragraph 35. Venture schools which were set up bona fide on need basis in our perception do serve students in remote places. And it may not be wrong to say that due to the inability of the state to discharge its constitutional obligations, the venture education institutions were allowed to function. We may also say that the state has been discharging its constitutional obligation to these venture educational institutions. It has got welfare state, my lord, obligation, education, subject it is education. In this backdrop, when the venture schools are taken over, the government in a sense is taking steps toward discharging its constitutional obligations. However, the action of the state in taking over such schools with only a given number of teachers, when the number is not commensurate with prescribed requirements of RTA Act, right? The law frame a relevant prescription is absolutely arbitrary. The spirit of 21A stands defeated right to education. 21A stands defeated in our perception if the mechanism prescribed under the RTA Act is not conformed to encourage those bona fide elements who have aided the state in discharging constitutional obligations.
Does Lordship said query, this Lordship, my lord, may kindly section 15, Lordship.
It's something different.
15 is
Those who are existing.
less, 15
and
is
those
Lordship.
who have been there in distinction.
Lordship, 15 part
Those
Lordship.
who are, which are not provincialized, what will happen to them? That is the purpose.
Lordship. 15 part Lordship.
Hmm?
15 drives a wedge between those venture schools
Lordship,
and institutions which were provincialized or recognized
Lordship.
or permission granted before
1 and 2006, Lordship.
And in those cases where the permission was communicated after 1
Lordship, Lordship.
where does it say that henceforth nobody will be-
That part, Lordship.
then one of the primary object of the act has not been addressed at all in this.
That part, Lordship, it is not there. Otherwise, by impliedly, Lordship, something, otherwise, Lordship,
Impliedly.
otherwise.
But you issue circulars.
That circulars, Lordship, in respect of
No, it mentions new institutions.
new institution, Lordship, in respect
Alright,
of,
you take note of it.
Lordship, we have already noted, okay, we have already noted down, Lordship. That part will clarify, Lordship. Will clarify. Lordship.
So even section 15, see subsection 2. Even section 15 that Mr. Gogoi is referring to, my lord, see subsection 2. 15.2. All such venture educational institutions which have obtained the required affiliation, permission, or recognition as the case may be, shall be allowed to function as purely private or non-government educational institution. Can they do it? Many of the teachers in those have been provincialized. 4,000, 42,000, 42,000. Where were they? They were not skyfallen. Now, my lord, therefore, what I submit, thus no rational government policy can justify such irrational provisions. You can amalgamate educational institutions, you have done it, but cannot provide for such bizarre mandates for provincializations and such bizarre cut-off dates. Cannot insist that there will have to be 150 students in the last examinations. In 2017 Act, my lord, it also suffers all these provisions. Absolutely unreasonable classification, also my lord, from another judgment, 96 volume 3 to DS. I'll cite one. Main cases I have already shown. One page, copy answer. Copy there. Only 2 paragraphs, 2 or 3 paragraphs. Yes. Turumugua, Tamil Nadu. And it will be more or less on this Supreme Court judgment, more or less on this point, my lord. Here, what happened? The state government says that no, if the medical council give you this thing, we must give you no objection certificate. Then you can open up new medical colleges. Yeah, that's why I'm bringing this case, my lord. Paragraph 34.
Paragraph 34.
34, straightway. Of this judgment, 96, volume 3, SCC, page 15. Paragraph 34. Also got it.
Yes.
It is no doubt true that in the scheme that has been prescribed under the regulations relating to establishment of new medical college, one of the conditions for qualifying criteria laid down is that the essentiality certificate regarding desirability and feasibility of having the proposed college at proposed location should be obtained from the state government. The said condition about obtaining an essentiality certificate from the state government regarding desirability and feasibility of having the proposed college at the proposed location cannot be equated with obtaining prior permission of the state government for establishing a new medical college as required under proviso to Section 5 of the Medical University Act. For the purpose of granting the essentiality certificate as required under the qualifying criteria prescribed under the scheme, the state government is only required to consider the desirability and feasibility of having the proposed medical college at the proposed location. The essentiality certificate cannot be withheld by the state government on any policy consideration. On any policy consideration, whatever. Because the policy in the matter of establishment of new medical college now rests with the central government alone. Here in my case, the universities go on giving affiliations and you say we stop no more venture. You cannot do that. University has to stop giving affiliation to any venture college. Has they? Have they? Paragraph 35. As indicated earlier, the trust did approach the state of Tamil Nadu for grant of essentiality certificate in terms of letter of intent dated so-and-so issued by Government of India. But the state government has refused to issue this said certificate by its order dated so-and-so. Only reason which given by the state government for such refusal is that the government have not changed the policy of not permitting any private trust or management to start medical dental college. This would show that instead of considering the matter of grant of essentiality certificate on the basis of desirability and feasibility of having the proposed medical college at the proposed location, the state government has refused to grant the essentiality certificate on the basis of its earlier policy of not permitting any private trust or management to start a medical or dental college in the state. The state government could not refuse essentially certificate of such a policy. The refusal on part of the state government to grant essentiality certificate in respect of the so medical college proposed to be established cannot therefore be upheld. So, be it technical education or medical education or general education, you cannot stop the growth. It is ever developing. Ever. Number of students increasing, literacy rate is increasing in Assam, everywhere. You cannot stop. Say that no more colleges. TNPI also comes in here. It's a fundamental right to open up a college by a locality. Where, my lord, within radius of maybe 15 kilometers, there is no other government provincialized college. The next, my lord, challenge in my petition will be section 8, subsection 6.
Acha, Mr. Babu, will you be able to conclude today?
I don't think. I surrender here.
Sorry?
I said I retire here. I said I surrender here.
No. Then we'll continue tomorrow. My brother has a single bench.
It will be up to your lordship's convenience. I am coming regularly.
We'll continue tomorrow from here. Yeah, Mr. Chakraborty, what do we do in your case? Who's the other side, Mr. Kyle? Where is it?
Any convenient day this week, Lordship?
Can it be after vacation?
Lordship has heard the matter, only one clarification is there only.
No, because till this is over, we will not touch anything. Tell us, after vacation, any day. We can have it on 16th.
16th. Lordship.
On the request of Planet Council for the this is writ petitioner, is it?
I am this side.
The respondent. This matter is directed to be listed again on 16/7/2024 as a fixed item for hearing. 16/7.
Highly obliged.
We put all this in record, and in these matters, we write. Hearing remains inconclusive today. List these cases again tomorrow for further hearing.